In your judgment of the trial court by permitting defendant number 2 to file counter claim against defendant number 1 and not against the plaintiff. We therefore allow the appeal.
Grateful.
Would your lordships consider allowing my counterclaim to be treated as the plaint, so that my right to claim file the suit may not be
Nothing.
obliged?
Mentioning item 801.
Sure. Jayaprakash,
14. Any date convenient to my last one.
date did it. We'll give it.
Grateful.
19th
it's-
September.
Pardon, my lord?
19th September.
19th September. Obliged, my lord.
Not to be deleted. 7th October.
Grateful.
Lordship, I'm requesting it to be listed on Monday. There's a stay operating against me. It was showing for Friday today, but it has not been
Monday.
gratefully.
Early date did it.
Great.
Item 805.
Lordship,
22nd.
not to be deleted.
26th.
26 September, not to be deleted.
So 807, the lordship,
28th of
lordship,
October.
they are perishable in nature, that they'll expire on 1st of October. Lordship. Is the application on Monday or Tuesday?
last
Lordship?
week we have done. Last week.
Lordship, they'll expire on 1st of October. They are perishable in nature.
Giving you this.
Can
Last
it be
week.
next week, Lordship?
We'll give it in the last week.
Because the radiation has to be done. Lordship.
6th of October. 808. Not to be deleted. 22nd. 22nd. Not to be deleted. 810.
My lords,
It's a regular matter.
yes, my lords. The issue is that the court of inquiry was convened in 2017, and the trial is almost stayed because of the appeal pending before this court.
Hearing expedited.
My lords, if a fixed date may be
Next
given.
item.
811.
May it please, my lords. My lords, in this matter,
19th. 19th. Not to be
19th of
deleted.
deeply obliged, lords.
26th. Not to be deleted.
My lordship.
My lord,
Regular matter. What do you want?
85 years of age, my lord, man. He is staying in Malaysia nowadays. So this is the situation because of health condition, my lord.
Hearing expedited. Yeah, love it.
My lord.
My lords, may I please mention IA 1959?
I unlisted mentioning, put it up in the mentioning. Come, put it up in the mentioning and come, no oral mentioning.
Please.
Everybody follows that, we should also follow. Next.
Item 1.
Please, my lord.
My lords, I have taken instruction. We have no objection to that one.
We'll allow the transfer.
No, blessed.
Don't do such things. Next time,
Sorry, my lord.
you will impose costs if you do that.
Sorry, my lords.
We'll allow it, we'll allow it.
Much.
Lords, and I have,
Please have two orders with me.
so I filed that small status affidavit with respect to UP with the status of the cases. I filed it late. It may not be on my lord's record. It's 2 pages, my lords, if I can just.
What is to be done?
It's just, my lords, in this one matter, he's got bail. The other matter, actually, he's not applied for bail. He had given a notice to the state, but nothing has
Then
happened. My lords may pass
is
any orders
Is
with my lords.
referring to some order by virtue of which
Can I just
it
show?
was granted and he was
That's
permitted.
in other cases, my lords. I'm just referring to the UP cases. I have, because my lords had asked.
Can I just show 2 pages? Your lordships will please just have page 42 of my application. This is IA 223674.
You know, close that up.
So I was accused in 54 cases. The main case was the CBI case. I was granted bail in the CBI case. But because I was either not granted bail in other matters or I was unable to even furnish bail bonds in other matters, despite the fact that your lordships released me on interim bail, I could not be released. Please have page 42 of my application. Your lordship said that irrespective of any other matter,
There is no 42 here. Does pass a similar order?
that's all that is. So I just want to show 2 pages and the order, my lords, that I wish your lordships to pass in my favor if your lordships are so considerate.
Petition seeking exemption.
Let's please have page 42 of my application, IA 223674.
7.4 we have it.
That's right. No?
At page 42 is an application seeking exemption from filing. Is there a particular annexure that you are referring to?
It should not be the order of this court,
Dated?
which begins at page 36, annexure A5, dated 11th of July 22.
There's no A5, sir.
The application should be dated
What was this?
20th of September 20.
Finding the failure. को दिखा देना.
20th September 24, 100 odd page application.
You gave a wrong number. कौन सा page ढूंढ रहा था? Which page are you referring to?
Just please have page 36 where the order begins, annexure A5.
हाँ, ठीक है.
And please come to page 42.
Yes.
Para 1 under the heading IA 8824. By an order of 21st of June, a bench of this court had allowed the application for release of the applicant on interim bail for a period of 2 weeks. The applicant had sought bail on the ground that his brother died. The grievance is that despite the order of release on interim bail, the superintendent of District Jail Jaipur has not released the applicant on the ground that the release order has not been passed by all the courts in India pertaining to all the FIRs registered against the applicant. A statement to that effect is made in the interlocutory application. Now please have para 6. The order of this court shall operate notwithstanding the pendency of any other case or the issuance of any production warrant in any other case for a period of 2 weeks from the date of release on interim bail. This was an order passed in my favor. The other thing I want to show is please come straight away to page 50 of the same application. This is in connection with a co-accused where your lordships declined bail in other matters but passed the direction at paragraph 8 and 9. These are para 9. For the aforesaid reasons, we are inclined to dismiss the applications and the writ petition filed by A6, giving liberty to file bail applications before jurisdictional courts. However, taking into consideration all the difficulties expressed by the applicants, including on the ground of ill health, we are inclined to extend interim bail granted to the applicants for a period of 3 months from today to facilitate them to seek bail before the courts concerned. We make it clear that the applications are to be dismissed. This is the limited.
First of all, give you bail.
This is the limited direction because I seek today that I should be released for a similar period on interim bail in all matters so that I can either approach this court.
For how long you want us to give this?
3 months is what I had.
We will do that.
But I'm only appearing for UP, my lords. He's already got bail in one matter. The other matter he's not appeared. The other matters, other states, my lords, I cannot say anything about that.
The circumstances in the present case are similar to the situation as recorded in our order dated 11/7/2022. वो भी लिखते हैं. वो भी लिखते हैं. 20?
The co-accused is 5th of September 23.
हाँ. नहीं, वो तो है. So we don't need to refer to the 11th September at.
Your lordships may pass an order in terms of 5th September 23 with para 6 of my.
Okay.
I move.
No. Situation in PSEL versus Central Bureau of Investigation, IN number 156411 of 2022,
Yes.
in batch dated 6th September 2022, as per which the following order was passed. Para 9 le lena at page 50.
That's 6. Of this 11/7. So what?
Month. Petitioner will be released on bail. I'll tell you what conditions. For a period of 3 months from today.
Please.
This is to enable him to move such applications as may be necessary for obtaining regular bail from with respect to cases that are pending in different jurisdictions.
Could I request one? 3 months from the date of release, if your lordships don't mind.
3 months from the date of this.
Applications on their own merit, not to be driven.
Okay. The jurisdictional courts will consider the applications on their own merits.
Because your lordships will have to reiterate that para 6 and 7, that I should be released notwithstanding the fact that.
You've taken that.
I'm extracted it. Huh?
That's right. But in your operative portion, your lordships may have to say that.
The petitioner will be released. नॉर्थवेस्टर्न कहाँ पर है ग्राउंड पे ना
that is it right now.
The order passed by the court shall operate notwithstanding the pendency of any other case or the issuance of production warrant in any other case for a period of 3 months.
I am most to blame.
The date of release.
I am most to
Please,
Mate, please.
because the NIS filed a short affidavit, additional affidavit
We filed a response.
about, yes, the my lords, would your lordship be pleased to consider two small prayers, my lords? The number one is, my lords, in the trial court, the matter is kept on 19th for the purpose of orders on the discharge application. My lord. I am only praying, my lord, two. Number one, my lord, the trial court may be directed to expedite the trial one. And number two, my lords, considering the potentiality of this accused, my lords, kindly give us 6 months time to examine the material witnesses who are vulnerable witnesses, my lord. And thereafter your lordship may consider.
Who are those? Who are those? Who are those witnesses?
My lords, those are the witnesses directly in connection with the kidnapping or abduction of that victim, my lords, taking him along. My lords. Those
As
witnesses.
far
Mansukh Hiren is
Yes, well, Bansky is the victim. He is
liquidated by them.
the other witnesses who were there. So
insofar as
kindly give us 6 months after framing of the charge, the lordship may that much indulgence may find.
there are accused number 10, 2, 3, 4.
That's
Their role is different than the role of this
You should
accused.
have indicated how this man's role is very different from that of others.
My lords, he is the actual person who has abducted this person, my lords. He has used the forged car number also. He has used the mobile, which was used for the purpose of this. He is in the police department.
Mansukh Hiren, he was the one responsible. For that.
Mansukh Hiren, he is the person who has abducted him all the way from Thane to Kandivali, my lords.
I indicate.
He is the main.
Role has.
Major
No, for with reference to 3 other persons, I'm not even getting into the issue of parity. But please have accused.
A3, A4, a Nathan.
No, please have A10. A10.
Nathan, we were party to that.
I mean, A10 is a role which is extremely similar. And may I just say this? Today, Milad, my learned friend says 6 months in order to conduct vulnerable witness action. Today, it presumes that that the honorable court will frame charge against the other person. The charges will be framed and the certain aspects.
Framed already.
As far as I am concerned, my discharge application got dismissed. I am pending in the Honorable High Court. For the others, the issue is on pending framing of charges. Now, one can't assume today that the court is going to dismiss the other co-accused person's discharge applications, actually frame charge, what the contours of that charge will be, what is the kind of hearing. Today, 4 years and 3 months, 4 months have passed.
Right?
Police officer.
You are a police officer.
4 years, 4 months have passed. I am not in service anymore. I'm dismissed from service. There is no propensity to either flee nor to.
Dismissed. Dismissed from service, my lord. If I may interrupt. Not dismissed from service.
It's okay. It is clear. The petitioner is
On conditions.
conditions. Madam. The petitioner was arrested on 23rd of April 2021 and he's continues to be incarcerated. Full stop. We are also informed that accused number 2, 3, and 4 are released on bail, but it is clear that
A10 also.
they stand on a different footing. Full stop. The situation so far the petitioner is concerned is more or less identical to accused number 10. Full stop. It is admitted fact that the appellant, the petitioner has spent more than 5 years More than 5 years?
4 years,
4 years, my lord.
4.5.
4.5 years. And charge sheet is also filed, right?
Charge is to be framed, my lord.
But the charge is to be argued, not framed. Let's be very
We
clear.
are at a stage when charges are to be argued.
Argued.
Charges are to be
Be
framed.
argued by other accused.
Charges are to be framed.
Not argued by the other accused, not others have sought discharge, not my discharge was dismissed. Bombay, there's
You
a
are
practice.
appearing for the same party.
Yes, but I'm assisting.
I'm
him.
sorry, Mr. Luthra was not.
I came in later, Lord. I'm sorry I interrupted, Lord. Without permission.
Explain the facts and circumstances of the case. We have an opinion that petitioner should be released on bail subject to such conditions or additional conditions that the trial court may impose itself. Needless to say that if there is any violation, the prosecution will be entitled to apply for cancellation of bail.
Most obliged.
But the trial court should not adjourn it without justification, my lord. Well, otherwise, my lord, the trial proceeds, my lord.
And the things we don't cooperate with. The petitioner shall cooperate with investigation, not investigation, cooperate.
Process of trial.
Cooperate with the process of trial.
I'm most obliged.
And shall not take unnecessary adjournments.
Lord.
Sorry, Lord, I interrupted without permission, Lord. My apologies.
Four,
Yeah, please, my lords. My lords, on the last occasion, my lords had desired an affidavit to be filed by the respondent giving the stage of investigation. Now, if my lords just has a look at that affidavit, it's completely vague.
No.
Other than, may I just?
Sorry, yeah, please.
My lords, it only says that the investigation is at a mature stage. Now, my lords may bear in mind that this FIR is of 2023. The petitioner was arrested in April 24. So nearly 2.5 years after investigation.
pardonable, Vishal.
My lords may just give me 2 minutes. Just 2 minutes, my lords. I'll make good what I'm trying to say, my lords. 2.5 years of investigation, my lords. 16 municipalities, and as per their own case, only one charge sheet filed. There is no supplementary final report, although they say 5 other municipalities have been investigated. Please, my lords.
You are A1.
Yes.
Please, my lords, in the charge sheet that is filed, the allegation is that his company was being used for. My lords, may I just show one chart in my.
Filed on the direction of the Honorable High Court, ma'am. I'm sorry.
Please. My lords, may look at their affidavit for a moment.
It doesn't matter, you tell us what has that.
So, my lords.
Your strength is not to be drawn from their affidavit.
I understand, my lords. What I'm trying to convey to my lords is this: that 2.5 years of investigation, 16 municipalities are the subject matter of investigation, and only 5 municipalities have been at best investigated. The quantum of trial, my lords, insofar as the one charge sheet that is filed is 31 documents, 37 witnesses, my lords. There is no possibility that this trial will conclude, my lords. All the documents which are sought.
March 23.
24. 12th April
2024 in this FIR, but otherwise, my lords, may I just make one point, my lords? Please have a look at a chart.
Because yours is not an ordinary case. Yours is a case where the OMR sheets are all tampered. Thousands of children, thousands of people.
My lords,
You are tampering answer sheets, question papers, and then giving it to people for money.
I bow down, my lords. My lords, in respect of the teachers.
One instance, so many municipalities, you have these links.
My lords, I bow down. I'm only saying that in respect of the teachers employment scam in Calcutta, the same allegation was qua the Minister Partha Chatterjee. My lords granted bail. Both in ED as well as CBI, I'm carrying those orders, my lords. My lords, he cannot face incarceration indefinitely.
Charge sheet?
My lord, 60 out of.
Charge sheet is filed?
My lords, only for one municipality.
But now
16 municipalities.
Can't be given.
I'm instructed to say, my lord, that out of 16 municipalities, investigation is over. But what we are hung up at is that a lot of OMR sheets were fabricated and forged. We are unable to locate the person who forged those. So I'm praying that we need 3.
It's at a sensitive stage.
My lords, it's not
Vishal, we will not
mentioned
grant
in
you now.
affidavit that 16 municipalities.
You withdraw and renew it after some
My
time.
lords, allow me to place one chart. Just for my satisfaction, my lords may have my additional documents where I've given a chart how these investigating agency, ED and CBI, is playing a ping pong ball. The moment he is likely to get bail in one matter, he's arrested in the other.
Okay, that happens.
Page 8 of my additional documents, my lords. P10, annexure P10.
Let's see this.
Yeah.
Yes,
Does my lords have P10?
yes.
My lords may look at the rightmost column, ED. He was arrested on 20th March 23. So effectively, he's been in custody overall, if you see, for more than 2.5 years. He's likely to get bail because I'm in the midst of my arguments in the Calcutta High Court when he's shown arrested for the first time on 12th April 2024 in this matter. Then, my lords, despite not being named in the predicate,
All those things don't impress us.
But-
What impresses us is that investigation is not fully complete. There are many more municipalities with respect to which OMR sheets and other things need to be looked into.
My lords, he's on bail in three matters.
Withdraw, you want to renew it, or shall we discuss?
All documents are in their
So
custody.
you made your argument. You have made up my mind, our mind. So what do you want to do? You
My
want
lords,
to
I'll
renew it
withdraw
after
with
that?
and my lords, I'll withdraw with liberty. Would my lords then put a condition that investigation be completed in 3 months?
When Vishalurti seeks to withdraw the petition to renew the
Would my lords just give me time to take instructions?
to renew the application after 6 months.
My lords may make it 3 months. Because my lords,
3
this
months.
statement is coming at the bar for the
3 months में हो जाएगा.
they said
I
it's
can't
complete.
promise, my lord. I can't promise because a lot of loose ends are still
My lords, it's unlikely.
connected.
3 months. 3.
Grateful.
Like,
Lord's challenge in this SLP is an order dated 19th of May 2025, whereby, my lords, my application for regular bail has been dismissed. I am in custody since November of 24. My lords, I am in custody.
Identification is there in the CCTV.
No, my lords, no. I have been only arrested, no recovery, nothing, my lords. The order is wrong to the aspect.
Some other accused are filed and
Yes, my lords, notice has been issued, P16, my lords, same FIR. Same FIR, my lords.
So you
My
should
lords,
notice post along with that.
yes. And that SLP number is, my lords, 12032.
Post along with that. You should notice post along.
Tagged with that, my lords. Highly obliged.
May it please, my lords. My lords, Dr. Singhvi is also in the matter. My lords, I think he has to be unmuted because I got something on the chat box.
No, I was waving. I'm sorry.
What happens today? Is it what all this has become infectious?
No,
or
Malas,
what?
we are suggesting,
not
Malas, we are
allowed.
suggesting by the IA.
Leading.
Malas, may I just answer my lord's query? By the IA we have filed, we are suggesting that your lordships can dispose it off today because the resolution plan has been passed. My learned friend has appealed against an order denying him impleadment.
That we know.
My IA points out that the resolution plan approval itself
Who is
provides
the petitioner, Dr. Singhvi? Are you the petitioner? Who is the petitioner before us?
the petitioner is Malas called
No, who is the petitioner?
Association of Allottees.
Okay,
Association.
Dr.
May I just Malas,
Mr. Ritin Rai, he's on
Milord,
online for the
can I
petition.
just
Milord, I appear for the petitioner before your lordships.
so can I just make my IA,
And the
Malas? Can I
party-
move my IA?
Okay, Dr. Singhvi, we'll just ask him.
Yes.
Mr. Ritin, has this not become infectious?
No,
now?
Milord, because
right.
the regular second
Point
appeal
is
in
now
which I have
considering an application for impleadment at this stage.
your lordship may hear the main matter because Milord,
That's
the
in the
regular
second
second
appeal.
appeal in which
What
I
is
had
there
sought
in the main matter? It's only an
Milord-
application against impleadment.
Milord,
in this
can
you are
I
saying.
Milord,
just-
the impleadment is in a suit proceedings which only affect me. Which is why I filed an order 1 rule 10 which was dismissed and I came up before your lordships. Your lordships in the first order recognize that I am the party affected in the suit originally filed by Dr. Singhvi's client. If your lordship has the
Malas,
first
can
order,
I
Milord,
just
I
raise
only
my
submit
IA
it.
for
If
2
your
minutes?
lordship,
Malas?
if your lordship
Rai
lists the main
clarified
matter.
that
You can't.
I
Everybody can't talk like this.
No, I apologize. Just
Milord,
let
can-
Mr. Rai.
The petitioner is entitled to open the argument and then we will ask the advocate appearing on behalf of the applicant thereafter because application is
Certainly.
listed today. You will just asking the introduction of the matter, then we will ask Dr. Singhvi.
Very well.
Yes, Mr. Ritin Rai.
Milord, these proceedings arise from a suit filed by Dr. Singhvi's
No,
client.
in a second appeal, you filed an interlocutory application
Because-
for impleadment which is rejected.
Yes, and I filed it on the basis that I am the person or the association who is directly affected by the outcome of that proceeding. That argument remains exactly the same, my lord, notwithstanding the resolution process that R1 has gone through, respondent 1 before your lordship. This is not, my lord, an IBC claim where my claim stands extinguished.
We are only confined to considering the question as to whether your application for impleadment should be allowed or not.
Exactly, my lord. That same.
Okay, that's a list between them. How are you concerned with that?
Yes, my lord. That's what I'm trying to explain, my lord.
Independent cause of action.
No, my lord. The list between them, the relief that my lord, my learned friend Dr. Singhvi's client claims, is against R1, respondent 1, and I have paid monies to R1 for booking of flats.
What? Till now, till the point of second appeal, what were you doing?
In the second appeal is where I filed my impleadment application,
Till
and I
then,
explained to the court.
1 minute, we are asking you, you didn't seek your remedies elsewhere. You didn't go to consumer court, you didn't file a suit, nothing at all.
No, because Mullah, the defendant in the proceedings is respondent 1, who had, my lord, received rights to develop a parcel of property. On those development rights, my lord, it sold flats to association members like me. The suit was filed by respondent number 2 against respondent number 1, seeking to recall.
Why did you not initiate any proceedings on the basis of cause of action?
My cause of action is not against R1, my lord. My defense is, my lord, that R1's rights to sell properties cannot be taken away by R2 residing from that contract. Your lordship may list, my lord, the main petition to be heard today, my lord.
Now, Manoj, can I say something?
We'll ask Dr. Singhvi now.
Now, can I just I'll take less than 3 or 4 minutes, please. I filed the suit in which, after Manoj's many years, he seeks to implead in the second appeal. Now, just turn to my IA and everything will be clear in 2 pages. Turn to my IA, which is 205218, and just see 2 pages with me, Manoj.
Tell us.
This issue, my learned friend says, Mr. Ritin Rai says that he wants to be present to protect his interest. Now, the resolution plan subsequent to all this is approved. In the resolution plan, the full protection of whatever he has to do is provided. So see those 2 things, in my IA for 2 minutes. Just turn to my IA.
Has he filed a claim before before CIRP?
He's a financial creditor.
He's an FC.
No, my lord,
he claims to be an FC, Malas. He claims to be an FC. And just turn to 2 pages, Malas, page 3. It'll take 2 minutes. Just bear with me, Malas. This subsequently, the resolution plan is approved on 8/9/21. The section 31 by the NCLT is approved on 7/3/25. Then, Malas, just come to page 4. A monitoring committee is constituted, which is precisely for the same thing that Mr. Ritin Rai may or may not want. The monitoring committee names are given, including advocates and non-advocates at page 4.
Ritin Rai's client is, what is his status in the CIRP proceedings?
FC. He claims to be an FC.
My lord, my friends are wrong, my lord. This project.
Applicant under section 9?
As an allotee, Malas, he says, I am an association of allottees in the nature of a FC.
And no, these are commercial projects. They're not.
And now, Malas, just 2 minutes more. At page 5, this judgment,
My lord, may I?
Well, he can't be a sidewind to a plan which is approved under monitoring committee's implementation. That's the short point, Bulus.
Why you are sufficiently protected in those?
No, my lord, my friends haven't shown the plan.
Only 1 minute, please.
This statement is made across the bar that I am an FC.
1 second.
Kindly have the plan.
Let Dr. Singhvi complete.
Yes,
145, just to go into one detail, Bulus, which is not in the page 145 of my MA has got my project. Relevant at 147, it directs R1, the SRA, to pursue, and therefore, Manoj, he covers everybody, including Mr. Ritin Rai. Just turn to 147. 145 at 147.
147 is the judgments of this court.
No, Manoj, 145 in my IA is the project, and the relevant portion is 147, which provides that in the SLP R1, who is the SRA opposing me, shall pursue the appeal pending before the High Court of Punjab and Haryana. That's your lordship meaning of a section 31 order. Kindly see that, Malas.
Yes, no, your lordships will see page 149. That's no, I'm just giving your lordships the correct page number. It's page 149.
Page 147, my lord, is what I was also going to refer to.
Yeah, my IA is 147, whichever IA lordship finds it. It is covering exactly Mr. Ritin Rai's point in the plan, but through the SRA. He wants to be an independent party. SRA shall pursue the appeal pending before the Honorable High Court based on the outcome upon disposal of the matter in favor of the SRA. The SRA shall sell the development rights within 6 months. Malas, he will destroy the plan by a sidewind.
What will happen even if we allow this application for him to be interested in that? What will be the
Yes, my lord. I'm sorry, my lord.
Therefore, Mullis, we are seeking that the appeal may be disposed of in terms of the subsequent development of the plan being approved and the SRA being given the rights to pursue the PNH appeal. Punjab and Haryana High Court.
That suit is still pending, right?
Second appeal.
Second appeal is still pending, right?
Yes, where SRA is given the right to pursue the second appeal.
But then what's the real harm if he is a party to the second appeal?
Mullis,
How does it
the
really
second
matter? Why are
appeal,
you contesting so much unnecessary?
the second appeal can be done only in terms of the plan now. The plan provides that the rights of the
So
second
therefore
appeal.
he's there because he is estopped, because he participated in the plan, and he can't say that the plan is on the left and I am on the right and don't follow
That's
the
correct.
plan. He's there, he's bound by the plan.
Correct.
So what's the big deal about
No, Mullis, he will prolong the matter. He will have a new party. He will.
Lord, your lordship may direct that the regular second appeal be disposed of, my lord, expeditiously also. I have no difficulty.
Can I
But
just-
the,
Lords,
but
can
the
I-
benefit of that second appeal, my lord, is to me. What my friend shows at page 145.
Lords,
The plan provides if the RA
Lords,
wins.
there has been no explanation given by.
Now he's speaking. Nakul has to speak.
Immediately.
Lords, can I just make one respectful submission? Lords, there is no explanation on why it took so many years to go and file this impleement application. Just one. Lords,
I think there should be some kind of a resolution. Unnecessary fights is
Lords,
Well, I have finished my submissions.
What I
Let
was
Mr.
just saying
Diwan.
is that we will permit him to be included in the second appeal, and then we will say second appeal will be disposed of in 3 months from today.
I'm grateful, my lord. I'd be very grateful.
Well, as the SLP would stand allowed then. The main
That's
SLP, which is not listed
the
today,
SLP stands allowed.
the SLP is not listed today, is the appeal against the implement. It's my IA to dismiss the SLP. Your lordship would end up allowing the SLP in my IA, Mullis.
No, not necessarily. That doesn't really matter. This matter is coming before us for the first time. We are rather surprised. In the initial stage, it should have been dismissed.
Mullis, then your lordship may do one thing. Your lordship may put the SLP down.
Because after notice issue from July 2022, we are in 2025. This matter has been pending here.
Well, then your lordship may put it down next week for the main SLP because it's not listed today. It's only the IAs. We'll get a holistic picture. Lordship may deal with the SLP. I don't mind. Let the IA remain. Lordship may take up the SLP on any Monday, Friday.
We'll allow. Okay, anyway. You're all taken by surprise.
That's right.
It was a tail wagging.
Lords, your lordship.
Your lordship may list the petition, my lord.
We will allow his appeal. Okay, next week.
I'm deeply grateful.
We will allow it.
Obliged.
My lord, may
Deeply
I
obliged.
my lord, may I request?
What?
My lord, may I request after 22nd?
1 minute, Mr. Ritanai. Dr. Singh, you tell us what kind of a protection you want. I will not drag on the matter.
Yes.
Not drag on the matter.
What else? What else?
All things which have happened between the parties in CIRP are binding on him. He can't
Yes.
rule out from that. Okay.
Well, my fear is that anyway, we'll make submissions next time. We'll make submissions on the next date.
Next week, list next week.
Deeply grateful.
My lord, may I request? My lord, may I request 22nd September? My lord, I'm in some difficulty next week.
Next week.
Deeply
My
grateful.
lord, may I request 22nd September? My lord, just 10 days from now. 22nd
All right,
September,
all
my
right.
lord.
Okay.
I'm deeply obliged.
On the next, yes.
I'm obliged, my lord.
May please, your lordship. Lords, this is only an IG for withdrawal.
I appear for the non-applicant.
Yes.
That is below the government department. I have to file a reply.
Petitioner.
I am for yes for the petitioner, non-applicant.
The award of 2006, my money,
But
since
then it's 2022. The matter has been pending. Suddenly you wake up and wants to withdraw now.
Yeah.
no, my lords.
I had to
Lord, there is-
deposit money is under an order of contempt. So I did it, but I don't think it should be withdrawn. I'll give you the reasons.
Leave granted.
No, my lords.
No, leave is not granted.
Then what is that? After notice matter. After notice is it?
Yes, my lords.
Below the 99 lakhs, below work order.
We will see. We will not grant an interim order. What we will see is in the next date of hearing, you tell us on the merits.
Yes, certainly.
To make it a point, we will
Certainly, my lord, certainly.
grant leave.
I think that's
Or
far better.
dismiss it.
Far better. Far better. Your lordship may keep it after my lord 4 weeks or 6 weeks.
Yeah.
My lord, there's some difficulty, my lord, in this week. I want it after Diwali, my lord. Give me a date after the break. After Diwali, any day. Yeah. Your lordship may give me a date on Tuesday, my lord, after Diwali.
Not Tuesday.
Yeah.
It's an admission matter. I don't know how notice was issued. We'll see.
Well, they said 340 crores. That's fine.
No, I'll show you, my lord, 99 lakhs has become 120 crores.
No, 33 crores.
That's the beauty of our arbitration.
Lordship, please.
Similar matters are pending.
Similar matters.
Sorry,
Similar, no, yours also.
no.
Similar matters are pending, item 8.
Please, my lords.
Issue notice post along with that.
Yeah, my lords, there are already other orders also whereby it was simply
Post along with that whole batch.
Please.
Accepting notice for RBI.
Who?
I'm accepting notice for RBI.
Notice.
My lord, item 8, my lord.
Item 8, notice issued.
Notice issued.
Post along with the batch.
Along with batch, my lord, one more help, my lord. That main case was listed in August 2024, my lord. Then after, from the past 1 year.
Can't do anything. We can't do anything. Mention to the Chief Justice. 10, item 10, 9.
Thank you, my lord. Thank you.
Well, Lord, your lordships have already held there is no distinction between debarment and blacklisting. The consequences are the same. Here, my lord, the debarment is done for 5 years and now say that we will hear you for blacklisting for 5 years again. Directly, my lord, contrary to your lordship's own judgments.
Notice.
And, my lord, pending confusion, my lord, whether pit mouth from where it can be removed, which was prohibited by your lordships in 21.
You have not complied with those.
No, I'm just saying, my lord.
Part of it is.
Lord, but kindly see.
Blacklisting is an issue. Otherwise, it's all right.
No, my lord, I am only flagging the issue, my lord, that the sand is to be removed, bajri is to be removed from the pit mouth. Your lordships in 21 passed an order, no pit mouth, you will have to keep it at distance. The rate which was prescribed in the bid was pit mouth. So the clarification was sought that if it is from the other place, I'm only saying, my lord, but
all that is all gas.
But your lordship, this is an issue, my lord, which your lordship would require to determine.
The aspect is, we'll see.
Very well, we'll bother your lordship, my lord, let them come and we'll, because
Point to blacklisting.
1.2 crore, my lord, has
gone with the wind. Notice.
not returnable in some time.
Notice.
This 9.1 is a similar matter.
Next.
9.1 is the same.
Similar matters were dismissed.
So for the state, my lords, I'm aware that there are identical matters which were dismissed. My lords, if my lords may just give me 2 minutes in the matter, my lords. My lords, the rules have never been challenged, my lords. It specifically mandates training plus the salary component, my lords. There was a 2-year probation before which the employees had quit, my lords. My lords, may please just hear me out for 2 minutes, my lords.
We are listening to you. We are listening to you. Argue.
My lords, the rule has become repugnant now that because of the matters being disposed of from the High Court itself, my lords, the rule has never been under challenge, my lords. There was this matter one in 2016, Jagdish, which was back then allowed. However, that has not travelled to this court, my lords. Therefore, other matters which have been pending in High Court, they are being referred to that, and therefore they are being dismissed, my lords. However, the rule is not being applied now, and it's practically impossible to apply the rule because it's become repugnant, my lords. If my lords may just.
You argued well. Similar matters have been dismissed. Thank you. Next.
Page 27, the regulation, material to the deemed generation under the regulation, the State Commission allows it, saying that, my lord, I will not claim only for the tripping. Finally, my lord, completely.
Notice.
What's it?
Notice. Delay contempt.
I'm taking a short pass over, my lord.
It's not a case of contempt at all. Discuss.
My lord, just a pass over, my lord, all I'm
You
doing.
tell us, if it is a marginal case, we will do something, but nothing. It can't be a case of. Tell us.
I do not have the instructions to.
Pass over.
Thank you.
My lords, in this matter, petitioner qualified doctor in medicine from Kyrgyzstan.
Qualifying examination conducted.
Thereafter, he came India and appeared various.
You believe so many times you failed.
No, my lords. I just want to my answer sheet be placed before the.
We don't want this. Croatia, is it? Kazakhstan.
Yes, my lord. Only request, my lords, my answer sheet be placed.
Citizens.
15 years ago.
Sorry, dismissed.
No, my lords, kindly 1 minute. Kindly give liberty to withdraw.
Dismissed as withdrawn.
With liberty to file LPA before High Court.
Okay, all right.
Kindly liberty may be given, my lords, to file a LPA before High Court. Kindly.
Needs to withdraw the special petition to avail alternative remedy. Permission granted, as sent to dismiss.
My lords, it is only when the respondents were found to be deficient in services, my lords, the refund was ordered, my lords. Instead of complying with that order, they filed an appeal before the National Commission. Under the orders of the National Commission, they deposited certain amount in my account. Thereafter, I moved an appeal before.
That's part of it, right?
Please, my lords.
It's all related to 9%.
Millets,
Enough.
Millets, I'm asking for the alternative relief. If Mallards would look at page 199 Millets, I asked for the alternative relief for the position of the plot Millets. May I please see the prayer Millets? Page 199.
9% is good.
Millets, I am not on the interest, but I'm. Millets, within a span of 1 year, I deposited 90% of the amount, Millets. They enjoyed the entire amount. Ultimately, I need a plot, Millets. I requested for that also, Millets. But the High Court has only considered the prayer of the interest amount.
Thank you. Thank you. Dismissed. Similar matter?
Similar matter. UPI.
Similar matters there? Notice post along with that.
Lord, I'm appearing for R3.
Take notice.
I take
notice.
Your Lordship, I am the petitioner in item number 15.
You are issuing notice, sir. Post it along with that other batch of matters.
Kind.
16.
Kindly have.
Yeah, in some other matters also.
All of them are listed. Last time, my lord asked
against Krishna Dikshit.
My lord, sir, no, not like that, my lord. The point is, kindly see that
To all those batch of matters.
all.
They have unnecessarily got accumulated.
My lords, it's 103 days delay.
I know.
No, no, kindly see 16.1, which is the first one.
103 days is hardly.
303 days. 303 days. And what the court says.
There's only one matter here.
My lords, so
Today.
today there are only 3 matters listed.
6 matters.
In which actually notice has been issued in only one. So we are entering appearance in 16.2.
What you
There,
do?
my lords,
what
we
you
have.
do, Raghavendra?
My lord,
Just make one statement of all this.
we'll do that.
We'll post it next week. We'll dispose it up. This is not a case which
Lords, with great
should hold
respect.
the Supreme Court.
Precisely, my lords,
Make a statement of the amount of delay
My
and
lord.
kind of a reasoning,
My
and
lord.
we will consider it next week.
May I say something? Today 6 are listed, 5 notices, 1 counter they have filed.
Doesn't matter, sir. We'll
Very
vote all of
My
them.
lords, have it
Very
after 2 weeks because notice has to be issued in some of the matters. We have.
Sir, deliberately we have not issued notice.
All right.
You take note of them. I will look at it. It's only for consideration of delay.
Honestly, my lords, we are at a loss to understand what the substantial question of law is.
Nothing.
I'm obliged. We'll make
Nothing,
a,
only for the reason that the learned judge says, condone the delay subject to giving him so and so book to him to read. Condone the delay subject to he giving a cup of coffee to the other side. Like that, he has passed orders.
And my lord, Supreme Court cases, decisions are
We will just
saying Lord Coke
clarify
said
that
something.
position
My
and
lord,
dismiss all the matters.
no difficulty, my lords. We'll make the
Ask
list.
them to go back and argue the.
We'll do that.
Obliged.
Please,
Obliged.
Yeah.
17, my lords, there is already an SLP that has been filed against the same order in which my lords have granted a stay. I can hand it over.
Why? How come notice was issued in this?
Why, my lords, is because it's actually very unique facts. 1946-47 is the assessment year in this case.
Similar matters then.
Similar matter is pending.
Notice.
30 years after there is a auction purchase set aside. That's why, my lords, possibly.
18.
May it please. This is an appeal from a contempt petition order.
Post along with the उसमें पैसा किसके है ना? Notice tablets also.
Sorry. The operative directions of which believe there has been a contempt is at page 160, my lords, in the single judge's order. So if your lordships would just come to the directions at para 32 at page 160.
18.
Sorry, item 18, my lord. We are top sports persons who were absorbed into the police in Punjab.
Notice already.
No, this is a fresh matter. But I'm hoping that's what your lordships will do.
But we thought, I think we confused with some other matter.
Perhaps.
Tell us, Gopal, what
Well, it's page 160 are the directions. The background is that I'm the Asian Games gold medalist, etc. We've been absorbed into the police in the early 90s. And over a period of time, we've been promoted in the regular cadre. And we moved all the way up to SP. Some subsequent challenges are made.
There is no deliberate disobedience.
No. So on that, there are judgments of your lordship which have made it clear that if there is lethargy, official delays, absence of motivation, etc., it would amount to
They
willful.
did their best, I say. In fact, originally as it was,
So
you couldn't have got anything over and above 10%.
no, so I'll just explain. I am in the 10%, so I'm not outside the 10%. Three points of distinction, which is why against that single judge's judgment, which is in my favor, I had filed an LPA. I went to the division bench on one part of it saying that your 2011 notification, which is being referred to, doesn't actually apply to me at all.
In any event, not a case of a contempt.
It seems that they have gone beyond the 6-month period and they've been casual about it. Now, leaving that aside, then
What's the other remedy you have?
My remedy, which I had, was that I had my appeal pending before the division bench. When I filed my contempt, the single judge on the 20th of May says, "Look, you take a call between the appeal that you filed and the contempt." So then I go and withdraw.
Revise your LPA.
So your lordship may give me the liberty. I'll file a fresh LPA, but just give me the liberty to file a fresh LPA.
Clear in our mind that there is no deliberate disobedience of the orders passed by the High Court. In this view of the matter, the High Court is justified in dismissing the contempt petition, not entertaining the contempt petition. However, the petitioner will be entitled to move such applications as
appeal,
such application for revival of the appeal.
Very well.
And the High Court shall consider the same on its own merit. With these observations, the special petition stand dismissed.
Very well. I'm grateful.
There are similar issues entertained by this honorable court. But the question is whether the assessment under 143(3) can be sustained just because there is an inspection and search, my lord, at the third party premises. My lord,
should we be pursuing this?
My lord, no, yes, my lord, because these are
similar matters are there.
Similar matters also there in
MSSE.
Yes. Not same as from a different high court. If 153C, my lord, is not at all applicable, we have done under 143(3).
You're saying wrong section is required.
Wrong section is invoked. According to me, it is a correct section. They are invoking a wrong section on the ground that there was a search by the third party. But the incriminating material was not found in the search of the third party. This was found in the return itself.
What's the question of law? How much is the money? How much is the money?
Milord?
How much is the money?
3.68 crores, Milord. No, that's the addition.
Additional income of 26.
No, additional income which is 3.68 crores. Tax effect is 1 crore 19, Milord.
Sorry.
Milord, it's the same issue, Milord, which is pending, Milord. It is Milord, the Honorable Court, Milord, has found that it is not a case of section 143(3). Milord,
in that.
Milord, same issue is pending before this Honorable Court, Milord, in Mahavir Prasad Gupta. Milord, same batch, Milord. Your Lordship may see the order. Milord, there was a conflicting view of the Delhi High Court which prompted this Honorable Court to entertain the case.
Those appeals never get taken up and then you keep on piling up.
Milord, here I have done a 140.
Is it some serious implication? Of
it is, Milord, according to me, Milord, the section was correctly invoked under 143(3). There was no third party material on the basis of which I am doing. Milord, there is perversity in the order of the tribunal.
Right, to that extent, we have noted that
Milord,
reference to the wrong section.
Milord, in fact, there was a split verdict by the ITAT.
The other connected matter also identically.
Yes, there also they said you must do it. It is identical. They said it was under 148. The only difference is here it's under 143. 148 is a reassessment.
Notice post along with.
There's a delay also, Milord.
How much is that?
245. Milord, the Lordship may order notice in that also.
245 days. Dismissed on delay.
Milord, whole effort is waste. Milord, Lordship may can't.
No efforts here.
No, I'm submitting.
So therefore, your question of law is kept open. It will be self-dismissed on the ground of delay. Question of law raised by the D.El.Ed Additional Solicitor General is kept open for being considered in an appeal. Yes.
May it please. With my humble submission, this matter requires consideration. The question of domicile-based reservations in national law universities, specifically in the...
No, we have gone past that stage.
So please have, there are two issues.
That's the stage. NLUI.
But the fact that...
I had appeared for them. That's all gone.
In fact, may I say...
No, every university has taken it up.
But
and then there is a value in it.
Could your Lordship
from them?
Could your Lordship see the process issue first before I get
to the elitistic institutions?
Well, please have two issues which squarely arose and what the Honorable High Court does. Please first have with me
Tell us.
the finding of the Honorable High Court.
Tell us in your own words.
The first issue was the power that was exercised. The Honorable High Court says that under Statute 12, read with Section 15 of the Act, the power to make this policy decision was there with the Executive Council. The square issue was this action was taken in January of 2022, that 21, the power was actually given in December of 22.
Yes, you are not.
Could your Lordship just...
1 minute. You are not impressed on the technicalities. Larger principle you tell us. If the state government gives land, gives all resources, it gives complete support, it says give us some percentage for the domicile of that state. What's so wrong?
Well, first of all, I will rely on your Lordship's judgment.
It says that you have to give 60 or 70 or 80%, I can understand.
May I say this? Your Lordships have laid down principles on the basis of which either institutional preference or domicile-based geographical discrimination can take place. Central to those is the fact that there must be some data to show that the students of that particular state are actually at a disadvantaged position. In this case, the peculiarity is a report was made. A report was made.
Not on the basis of a disadvantage or anything like that. It's about the fact of the state promoting and taking some steps. There was a very interesting case of a Punjab wanting to give reservation to the freedom fighters. So I have written on that. They gave initially freedom fighters of coming from Punjab, but later on they modified it, saying that it doesn't really matter. We'll give freedom fighters anyway. They fought for the country. That was a good thing. So
it was my submission for please consider. These are institutes, and this particular institute.
Identify NLUs are
self-funded.
Dismissed.
Would you not
entertain? Thank you.
I'm obliged.
When the council appears online, my lords.
Lordships. Lordship, the core issue is pertaining to the denial of equal opportunity to similarly situated persons.
In-house candidates.
Yes, your Lordships. All are in-house candidates, but they have limited the seats to number 32. And the total number of sanctioned strength seats available is 1:1, your Lordship. There are total 32 seats actually that's available, and 32 persons they have selected in the due process, and thereby totally denying chances to similarly situated persons to compete against a public post, your Lordships.
Sorry. Dismissed. Next.
Please, my lords. My lords, this is a peculiar case where, my lords, while on the first side it would look that the arbitrator is being overzealous, but, my lords, she grossly misconducts herself by, my lords, assisting a party by visiting the collector's office. And then, my lords, after getting the stamping, etc. done, she writes an email saying that I have done so and so. So all these communications have happened unilaterally, ipso facto, I am being told, which gives, my lords, reasonable apprehension that the party and the arbitrator are connected.
Over anxiety here.
She's
a lawyer, is it?
She is. She is. And, my lords, this is a case with good 30-40 lakhs fees.
A lawyer. By chance, you would have become an arbitrator, so I wanted to know that enthusiasm.
My impression was the same.
About the enthusiasm, what is so wrong about it?
Well, as if an arbitrator starts visiting the collector's office, which is not the duty of the arbitrator at all.
But she has shown a little over enthusiasm. Over and above to allege it to be biased. There must be something more which you must say. What is that?
Well, there is an apprehension because once we know there are unilateral communications that have happened where I am not a party. I don't know of this because I only come to know through an email. If there is one such communication, there could be more. Because that raises the doubt that the party and the arbitrator have been communicating for administrative reasons. And then very interestingly, the single judge goes on to say that this is the duty of the arbitrator to in fact visit and ensure that the collection of stamp duty is done. Because if that is so, I don't think anybody would be interested in taking any arbitrations.
There's more than this. In fact, the single judge has also ordered the entire state machinery to understand how the provisions will work, how when an ad hoc tribunal is constituted, they don't have the luxury of staff. That's precisely the reason this may have happened. That's been noted in the order. And that's why Commissioner of Revenue, the Principal Secretary, etc. Everybody.
Flip side of it is that you are doing everything possible to ensure that the arbitration doesn't go on further.
Plus, may I?
It actually adds the tinge to your lack of.
Lordship is talking about this particular case, or Milos generally. This particular case, Milos, I am ready to make a statement. Lordship may appoint anybody, make Milos 6 months, 8 months, whatever time your Lordship will say. We have no difficulty.
How was she appointed by the
court?
By the court, Milos. Ex parte by the court.
Court appointed.
Milos, Lordship,
There was
there is no
a
difficulty.
affidavit of
Appointment by them.
No, Miller. That is not the case here. The court appoints ex parte though.
Then when did she take charge?
It was in December of 2023.
December 23, yes.
In fact, my lords, not going into the conduct, if my lords may just have the provision itself that says the
This case, as I said, Milos, at the beginning, first blush would look that she is overzealous, she's excited that she's become an arbitrator, no difficulty there, Milos. But if this is something that an arbitrator starts doing, visits the office of the collector without informing the other party, Milos may only see what the single judge just said in para. Lordship may only see that. Milos, that may have a problem. Yes.
We'll keep the question of law open.
Yes, Milos. And Milos may give me liberty to Milos raise this in a 34 then.
We have the opinion that the questions of law raised by him should be kept open for being considered in an appropriate case. In the facts and circumstances of the case, we are not inclined to exercise our jurisdiction under Article 136. So, especially.
Milos may give me liberty to raise this in 34, Milos, at least. I should be. Otherwise, I have no such remedy left after this.
You will be entitled to. The petitioner will be entitled to raise these questions before raise these questions as objections to the award, if necessary.
Lord.
You might succeed, who knows?
Lordship. If at all, that's right.
Please, Lord. This matter is concluded both in the PTC case and your lordship's recent judgment, my lords, in the Himachal Pradesh. Can I just pass your lordships? Here is 2014 regulation says it is leviable only after 60 days. Now my PPA said 30 days. I follow the regulations and I pay within 60 days. There's no doubt. Now years later.
PPA is 2006.
PPA is 2006.
Regulation is 2009.
9 and then 14. 9 had a carve out. 9 provided that you can amend. So I paid from 9 to 14.
Well, let's just read 334. So the answer is the regulation itself. 334.
That's
The answer
important.
is in the regulation.
That's an important. Does it say subject to agreement?
Yeah. No, Manoj. It says that if anybody has hardship, they should.
1 minute.
This is 2009.
2014 regulation. Manoj. 334, regulation 4 and the proviso.
Page 330?
334, Manoj. Regulation 2.4 at page 334 and the proviso, Manoj. The regulation itself, Manoj, the answer. It says, in case of any conflict between the provisions of these regulations and a power purchase agreement signed between a generating company and distribution licensee, the provisions of these regulations shall prevail, provided that in case of projects where parameters have been agreed to in the power purchase agreement or determined through an earlier regulation prior to 1/4/2014 for any hardship due to discrepancy, inconsistency with parameters given in these regulations, the Commission may be approached and parameters in such cases may be determined by the Commission at the time of tariff determination of respective generating stations.
They must
never,
have-
one second, they never approached.
They must approach.
Find the parameters.
They never approached. Hardship is caused to them. They never approached.
Not a hardship or anything. It's a late
Yes.
surcharge. Late payment surcharge.
This is a 25-year PPA, Manoj. We should kindly see.
It's a regulatory feature. Late payment surcharge.
But the proviso says if
Read
they,
it again.
provided that in case of projects with where parameters have been agreed to, which is
But
the
what does that mean? Parameters agreed to.
parameters means the surcharge will be within.
No, 337.
One second, Manoj.
What does parameters have been agreed to?
The
LPSC determined. What are those parameters?
The arrangement, Manoj. The agreement. The agreement has all the parameters. It's a commercial arrangement saying that
Parameters have been agreed to in the power purchaser or determined through
an earlier regulation.
regulation prior to the, for any hardship
Correct.
due to discrepancy, inconsistency.
Which is what it is.
Malad,
Which
page
is the
337 is your lordship's
That's
answer.
what he's arguing.
Both
Malad.
of you agree that this is relatable to the parameters?
Yes, of course.
No, parameters is at page 337.
Then it's not a question of tariff.
337. Just see what
Four.
parameters are.
The commission shall also carry out truing up of tariff of generating stations. It's already been held by your lordships that late payment surcharge is not a part of tariff. It arises out of it. Carrying out truing up of tariff of generating on the performance of the following controllable parameters: gross station heat rate, secondary fuel oil consumption, auxiliary energy consumption.
It's not part of
Nothing
tariff.
to do
Malad.
with-
It's worse for him.
Notice.
Malad, I'm seeking a stay, Malad.
So, Malad, stay over there. It's 120. In principle is 100.
Your lordship should hear the matter, my lord, because this is
We have succeeded.
a distribution.
Consumers will end up
pass it
paying.
on.
Well, let's just see the stay. What will happen is, if they ultimately don't succeed, they'll pass it on to the consumers. It's much better, Maharaj, that they deposit it. It's 129 crores is only the principal.
Say, under the PPA 1 month, under the regulation it is 2
2 months.
months.
And I paid in 2 months. That's not the dispute. Dispute I'm taking is in 2019.
After stay.
Maharaj, stay would
You are
mean,
hearing.
Maharaj, stay would mean, it would mean, Maharaj, that he would ultimately, if he doesn't succeed, who will pay? The consumer. Because it will be passed on.
Anyway,
So in this case, if he gives it to me,
It will go back as true up.
correct. End consumer will pay ultimately more, Maharaj, on tariff. If he gives it to me now, Maharaj, I will return it to whatever interest, Maharaj. No, I'm doing a practical thing. Instead of the consumer paying,
That applies to all tariff which they do it at their own peril. They suppose.
Maharaj, your lordship always says that because of your fault, the consumer is being punished. No. Therefore, why allow the consumer to be punished? We'll give a bank guarantee, Maharaj, that we'll return it with whatever interest. What is the problem, Maharaj?
My lord, if I pay
Yes.
today, then I have to immediately pass it. The truing up will come up with the consumer. Their rates will
you
go up.
don't.
My lord, I want to say this. I am
not
after
paid
all a
for 8 years
distribution
already.
company. They say they have a 25-year power purchase agreement. They can true up in the next year. There is no problem.
129 crores in the principal.
crores.
Some
My
part
lord,
of it you must
tomorrow if I do it, I have to pass it on immediately. It will now come up in the power tariff.
Only the principal.
My lord, I'm saying that is 120 crores.
Yes, we'll give the bank
120
guarantee.
crores. Then they are asking for, today it's not a question, my lords, of the payment for the electricity. It's only late payment surcharge. The whole amount is only the penalty. There is no original amount payable.
They must.
It's only the penalty, my lord.
Waited for 6 years.
We have the document, Mr. Sibal. Prima facie case, they have the shall be a
Maharaj, the
state.
judgment of the Supreme Court clarifies the Constitution Bench judgment, Maharaj. The judgment of the Supreme Court, Maharaj.
Dispose it off early.
Maharaj.
We expedited, put it up in the month of December for disposal. Tuesday ke din lagna lagna.
Maharaj, at least 50% should be paid. We have been succeeded. Maharaj, why should they get away with just stay, Maharaj?
My lord, it's
We
a
have
reversing order in any event.
50%
Commission decided in my favor.
That's
Appellate tribunal decides against me, saying the
Tell us, so far as the 1 month is concerned, have you paid them completely?
No.
Yes. My lord, so far as the LPS,
With respect to the 1 month.
no, the LPS today they are saying is because of the additional 1 month. And I paid that completely within the 2 months.
You done or not?
Yes. Within the regulation period of the 60 days, the additional 1 month, it has been paid. And I'm still paying.
30
I
days.
continue paying.
It's paid.
Yes.
They had to pay in 30 days, Maharaj. They paid after
That's
30.
the whole point. 30 days, 60 days.
Maharaj, I bought coal, Maharaj.
Under the PPA 1 month,
Maharaj,
under the regulation,
kindly see.
2 months.
they have already paid.
Yeah, the coordinating, I have to buy coal from outside, Maharaj, not from them. So I incur a greater loss, Maharaj. Therefore, some money must be paid, Maharaj. At least 50% must be given.
Give an early date. The matter can be
129
heard and
crores,
disposed,
Maharaj.
Maharaj.
After all, I have to incur a loss in the process.
Short point, man.
Subject to the appellant paying 60 crores to the respondent. 60 crores. 120 is all
129.
129, 60 crores.
Yes.
60 crores. And the respondent shall secure it by way of.
Malad, let me deposit it then, Malad.
No, we'll give it. You give it to us.
Malad, then please make a,
Bank guarantee.
Malad, then at least 25%, because this has to be passed on immediately, Malad. I have to rework my whole calculations. Malad, then at least 25% and I'll give it and let them give a bank guarantee and take it. let it at least be 25%. Otherwise, I have to immediately. And my lord, there's a reversing order. It's a reversing order. Commission agreed with me.
What? We've succeeded.
It's a reversing order.
Question of law will happen.
My lord, it's not that I'm running away anywhere. I'm right there. I'm not running away.
Neither.
He's a private player. My lord,
We just balanced it by saying 50%.
Obliged.
And we have also secured it by way of a bank guarantee. How does it matter?
your lordship will make one thing clear then. If I succeed, they will pay that with interest.
Naturally. Naturally.
Please make that clear. Please make that clear.
In the event, it's made clear that in the event the appeal is allowed, the amount paid by the appellant will be returned with interest.
My lords, please.
Any date?
My lord is giving a date for it.
Time in December.
But my learned friend has taken notice, in which case, my lord, they can just complete pleadings in the meantime.
Who is the advocate on record, Mr. Sibal?
Saluja is an advocate on record. I will accept notice.
Who?
Nitin Saluja is the advocate.
Nitin Saluja takes notice of the.
Grateful.
My lords, please.
Yes. 24 similar matters.
These are those medical admission matters which were heard that day.
Yes.
53 is my matter, which was there. I am the petitioner.
I am for the state.
Sir, I am
That's
the-
now state has come before your lordships.
This state.
I am the state.
We have both of you are supporting.
Both of us are not opposing the judgment.
And Millets, in fact, the contesting respondent has already secured his admission.
Contesting respondent has got a seat.
We both are opposing. I think High Court is.
Sir, your lordships wanted to hear it that day, Lord, because if your lordships recall.
Notice not gone.
Notice is gone. In my matter, notice is issued.
Who is appearing for the response?
No, because he has got a seat. He has got a seat already. The state is now coming appeal against the very same judgment. And Lord, I'm a national.
The sports.
No. The writ petitioner before the High Court has already got a seat. Has already got a seat on the merits. And this is, Lord, if your lordships recall.
Who is appearing for the other parties? The
other party, it is me.
If in my case, Millets notice is given tagged, they could respond. Because already notice has been sent in the other case.
Connected back.
Yes, Millets. We'll serve the 3 Millets.
Some protection has to be given. Monday it could be heard. Monday is the next round of counselling. Lord, if the seat goes, then Lord, again creation. So your lordship may say one seat may be kept, Lord. That freedom fighter seat shall not be filled up. Lord, here the issue is reservation is already there.
Change it.
Lord, reservation is already there. So one seat, please keep it.
Don't give unnecessary hope to your clients, Mr. Natkar.
Just instead, consider the matter. One doesn't know, Lord, what.
Millets, instead, may I submit one thing, Millets? Justice is given. Kindly post it next week. We'll inform and they may be ready because he may not have any grievance surviving.
He's been served, Lord, in the other matter. My matter is served.
Issue notice, post along with that. In your matter also issue notice.
Yes.
Post along with that.
Next week.
2 weeks.
Lord, next week your lordship is going. Lord, I'll take my chance.
Millets, counseling is 15th, Millets.
Lord, give a date, Lord, otherwise it will never come.
15th, Millets. Counseling is 15th.
We'll give a date.
Great. Steve.
My Lord, I'm seeking an adjournment in this matter. The instructing counsel is actually not well for the last couple of days. And I'd informed my learned colleague.
CIRP is issued. What is there for us to interfere in this?
Lashmi, just give me 2 weeks, my Lord. I'm not instructed in this.
CIRP of 24 November.
My Lord, please give.
This is a fresh matter.
The notice is.
It's a fresh matter, my Lord. No notice has been issued.
What stage is the matter?
The notice has not been issued. We had to come back with a plan and how much payment you were.
You seem to be regularly taking adjournment.
Your Lordship, only on the last occasion the council.
April 2nd of May. Why are you doing this?
Your Lordship, we had to give them a offer for repayment of the money. Then after that, the matter got listed in July where the councils, there was a demise in a family. And then second time it is coming, my Lords.
To enable the apprentice. Have you complied with the 17th April order?
Then it is recorded that is there not in a position.
Then what remains now?
Your Lordship,
Dragging on the matter, dismissed.
Your Lordship,
There's nothing in this.
Lordship, just give me 2 weeks, Your Lordship. I'm actually not.
Given enough number. It's not the first time you
Lordship, then let me withdraw this matter with the liberty to avail my other remedies.
dismissed as withdrawn.
And to avail my other remedies, my Lords.
Next.
Please.
My Lords, I'm seeking a passover. Mr. Rothke.
Well,
on
this
his
has to be finally heard, Maharaj. This
Well,
has
but
to
no.
be finally.
We are pressing for
taken
the
up.
status
The
quo.
Lordships granted status quo. in the first
Lordships,
hearing.
today, Lordship will hear on the
We
interim
granted
hearing.
because of adjournment. We didn't have.
Oh, I see.
Not at all on the merits.
Oh, I see. So in any case, I think it should be heard, Maharaj. This is my own.
Still, my Lord, for 2 months we are suffering, my Lord. For 2 months, the Aptel cut the baby in half.
Well, you don't have the power to give us at that rate.
You want to deviate from the contract.
What? You are,
Two
we are
periods.
not bound.
Only that later period they said that. 1st December 22
Yeah.
to 31st December 22.
Correct, correct.
And out of 15 days, they've given consent as well.
No, no, no,
They
no. we
gave
have
a
not given
consent order.
It's all.
And they filed a review. The review also got dismissed.
That's not correct.
Capital is given 2 out of 4 months. No, how does it go? 2 out of 4 months?
The original authority gave me 4 months.
Correct, correct.
I asked for 9 months. Original authority gave me 4 months. Now the
Question of law formulated.
the question of law is whether merely because I'm disentitled to variable charges, am I disentitled from fixed charges?
Okay.
And my lord, the government of India gave a clear direction during that period. Section 11 direction saying that because of abnormal rise in coal prices, you will be entitled to higher prices. Tamil Nadu, the DISCOM take advantage of that. The respondent takes advantage of that. And just for the 2 months, it says, I'm discarding the Section 11 direction. The tribunal says, once you have complied with the section.
Admit, as you have said, we'll admit it.
But that's actually for the 2 months.
See the problem. See the problem. You want the fixed charges. Let me explain. The fixed charges. Well, he imports coal, and contrary to the PPA, he says you buy electricity at my cost. We are saying we certainly not buy at your cost. He said there's a section 11.
No, because of the status code, I did not get it, man. Because
that's in our appeal.
In their appeal, your lordships pass a status code.
Yes.
Which is what is stopping us. I'm saying for 2 months, my lord, at least the interim arrangement, let me at least get the benefit of 2 months.
Benefit let him get.
Yes, but I'm taking a loan right now.
It's 4 months, right?
No, Malad, just see section 11, Malad.
4 months.
In section 11, Malad, it's the central appropriate government, which, Malad, in fact, gives the direction.
Subsistence of the section 11 notification.
Like section 11 doesn't apply to me, Malad, it's a direction to them. I have still got the right to say no. Malad, please see. See section 11.
He's been taking advantage of section 11.
Allow me, sir. Allow me, sir.
What we can do is,
Yes.
Direction itself says I can withdraw.
So far as the 2 out of 4 months, I think that's a very reasonable balance.
No, Malad, it's not.
Remaining 4 months,
We've already paid 50 crores, Malad.
I'm saying,
Where the matter was pending, we've paid 50 crores.
78 is remaining. 78 is remaining.
Just see one page, Malad, page 1, section 11.
We don't remember. 26. We don't remember when we passed that order.
Lord,
Because of time.
Lord, may I say this, Lord?
Interim order was passed.
Lord, may I say this, Lord? Lord, what we have said, Lord, during pendants.
Mr. Sibbar is there, man.
Malad, see page 186, Malad, it gives the answer.
Till the next date of hearing, parties are directed to maintain status. This is in your matter.
In their appeal, my lord.
In our matter.
Because on that day was time constraint, my lord. So lordship.
Lord, we had already paid 50 crores, my Lord. We have already paid 50 crores.
I'm saying the balance, my lord.
What?
No, they are not entitled, my Lord. They are not entitled. They are not entitled.
My lord, there is.
2 months you will have to pay. Huh?
No, Malad, that's not the
per
point.
original authority.
Kindly see page 187.
There's a consent given by them.
Either you are finished
No,
arguing.
no consent.
I'm arguing against my
Then
friend also.
Please argue then. Then I'll argue.
My lord, we have 2 points to make.
Come back to it.
Yes.
My lord,
These are cross appeals. The issue is of 4 months.
Hear them.
Lord, 2 months is given to me, 2 months is refused. What is given to me, they are in appeal. What is refused, I am in appeal. Lord, I am in a very precarious situation. These are tariffs, Lord, directed under section 11, where we were asked to produce, Lord, there's a directive.
We will say in modification of our order,
Yeah.
we will say status quo, in the sense that
There's already
2 months. 2 months.
2 months they should give me, Lord.
Then
I'll
please
be dead otherwise.
Hear me for a minute, Malad. Then please hear me for a minute. Kindly come to page 186 at 187.
186.
In our appeal. 26.1 in our appeal.
186.1
in our appeal. Because I've paid 50 crores already.
The PPA.
No, Malad. This is
186.
No, this is the section 11.
the section 11 direction which they are relying upon.
Are you in 26.1?
Yes.
See page 194.
186.
Just see 194. It's read 194, Malad. 194 at 195.
Very clear action.
Subparagraph A.
194.
At 195, subparagraph A, Malad. Annexure P6.
195. What is the document?
If the
That's
PPA
clarification,
holder,
is
this
it?
is the section 11 direction. Clarification, my lords. Kindly see, it is not a clarification to me. This is between them and the power generating station. What does it say? If the PPA holder does not wish to requisition power, which is what I did, does not wish to requisition power from ICB plant for the following weeks, then it will inform the ICB plant at least 3 days in advance, indicating the period of intended non-requisition. The minimum period of requisition, non-requisition shall be for a minimum of 1 week. So I do that at page 196. Tell him I don't want it. Because I don't want to pay a higher price. I'm a distribution company, Malas.
It's happening everywhere.
Yes, exactly. Now, Malas, see, I tell them 196. I say the power price is expected to reduce considerably during December, and average market power price from power exchanges has fallen below the benchmark rate of imported coal plant, and hence Tangentco has proposed to withdraw the approval given to supply RTC power.
Now just see
when I withdrew it. Now, one more thing. Then after withdrawing it, they themselves accept that I have withdrawn, which is at page 200 and 200. They know that I have withdrawn. Now they are asking me to pay. At the bottom of 200.
Without fixed charge is always payable. Number one.
No.
Now see 196. Now he read 196. Please read 196.
These are all electricity matters, nothing so emotional.
There's a lot of current.
All right. But I will show something to you after.
You don't need to.
All right. Let him show.
After all, it's just the generators are making money. So nothing.
We are a state, but
human rights are involved.
I don't have coal. I just want to show you. My friend wanted 196. Read the second last paragraph of 196.
Let me see 200.
He says I don't want it. He says I want it.
No.
What's the point of no? Just see 196. See 196, my lord. Last para. In second last. In this regard,
the real paragraph that he is not reading.
Let me read. You wanted 196. I'm reading 196. In this regard, SCPC is informed that power will be procured under the provisions of the PPA. He wants to pay the PPA. Yes. Central government said pay a fixed rate, which is a higher rate.
No.
That's the issue.
Say that,
How can that be, Milord?
No.
We will say 2 months you pay the remaining.
That's all. 2 months is 2 months, Milord.
That's our appeal, Milord. That means it's allowing it, Milord.
No, it's not.
Milord, 2 months.
My appeal is there for 2 months.
Milord,
you are a government corporation. We are a private.
We'll pay 50%. Then say that.
Why should
we pay? Yes.
Milord, 2 months.
No.
Milord, 2 months in any case is 50% of 4 months.
No.
2 months is
50%, Milord. 50% of the 2 months.
Milord, I have succeeded on 2 months as our central government directive.
Sorry. Quiet.
The Tamil Nadu Power Distribution Company shall pay fixed capacity charges for 1 month. For a period of 1 month.
Well, let's give me 3 weeks to pay.
3 weeks from today.
No, the Lordship may make it
an interim arrangement. This is an interim arrangement, and also in modification of our order dated. Which order was that?
14th of August.
14th August.
2025. Next, appeals are expedited. Let them be listed for. Let the appeals be listed for. Added to the final hearing list. In the month of February 2026.
Obliged. Deeply obliged.
Well, let them give a guarantee, my lord, for the amount we have deposited, and they wanted to withdraw it, my lord.
Now I hear Mr. Wilson.
Tomorrow undergoes liquidation, my lord, we can't recover it.
1 month.
They say
Guarantees by 2 months, which I will succeed.
That's all right.
May I please? Admittedly, no privity, my lord, between me and the airport authority. My lord, 167, your lordships come to, my lord. When they revised, even, my lord, throughout, the demand was against the airline concern, my lord. We are only, my lord, the ground handling agencies, a sort of subcontract from the airline to us. Page 167, your lordship turns to, my lord.
You want a note use certificate?
Pardon, my lord?
You want a note use certificate?
Yes, my lord. Note certificate.
Giving you.
Just had 16 million for the period of 2015-16. They are demanding in 2020. After almost 5 years.
What do you say? What do you say?
Page 167, your lordship sees. The demand is all through. Yes,
in
Let them file today.
leave granted. Leave granted.
My lord, in the meanwhile, my lord,
Is it a money matter, Mr. Bhatt?
pardon?
Is it only a money matter or?
Your lordship, don't do, because we can't participate in the, my lord, further auctions at all, my lord, because of this difficulty. Because repeatedly they are refusing no due to us.
That's because
we do not have
undertaking that they
our
will pay.
difficulty I will point.
This is unnecessary. Why don't you just
My lord,
sit down and then get it mediated? It doesn't really. It's not a case for a. Why it's a clarification is what is needed.
And your lordships have given an
it
undertaking.
is the airlines who have to pay. Today, my lord, Jet Airways is no longer in picture, my lord. We can't really recover from Jet Airways if they, my lord, make a demand of
We'll hear it. I don't think it's a matter for media.
the stay of this demand, my lord.
So that will not stay.
My lord, otherwise we won't get
Lordships have given an undertaking that
your
they'll pay.
lordship may say.
In case they fail in reputation.
My lord,
Where is the demand dated?
my lord, demand is 2020, my lord.
Huh?
2020, that is 22nd July 2020, my lord. For the period of 2015, that is at 169, my lord.
Unpaid dues.
22nd July 2020, my lord.
27 lakhs. They don't grant you no due certificate.
Yeah,
But then
on the basis of this demand.
Demand raised by you is by the
No, their demand. They made a demand.
against you.
Yes.
Against you.
Yes, on,
How much is that?
my lord, that is about
27 lakhs.
1 crore and odd.
Issues pertaining to royalty.
That's all. The whole thing revolves around the legality and validity of the demand. That's all.
That's right.
And your lordship, they
That's-
gave an undertaking that
The
they will
ground
pay.
that it is, they have no privity to demand.
That's right.
They will not. Any payment made will be subject to the outcome of the petition. Leave granted, any payment made will be subject.
Let us participate, my lord. You may be allowed to participate in the auctions, my lord, because
No,
because
your
of this,
lordship,
you can't have it both ways.
Did they bar you from participating?
That's right.
Your lordship, they've
They
given
did
an
not give us
undertaking.
no due certificate. My lord. We were in fact successful bidders in one of the.
Your lordships may just have this order, your lordships. They're given an undertaking in case they fail in the writ petition, they will not dispute the disputed
Okay,
amount.
if you deposit, if you pay it,
Yes, let them pay it.
listen. You pay the money, we will clarify that they will not debar you from participating and the payment will be subject to the outcome of the petition. Okay?
Yes.
Okay. After hearing the leave granted, the petitioner shall pay the respondent as per the demand dated 22/7/2020. The payment will be subject to the outcome of the final petition. Pending disposal of the appeal, the petitioner shall be permitted to participate in further auctions, if any.
Only after the deposit, your
It is
lordship.
an interim measure.
Only as an interim measure, yes.
Right. This will satisfy both of you. Next.
Yes, grateful.
Lord, there was a common order passed in 4 matters. With regard to one, SLP has been admitted. The remaining, Lord, yes. Only thing is, Lord,
along with that.
under Order 7, Rule 11, the judge has gone into Article 363, Sarekala case and ignored Madhav India completely. Lord, he has also given undertaking not to proceed.
Along with that.
Same order may be passed.
Same order.
It's 687.
Same order, same.
Yes, ma'am.
If you notice, same order. Thank you.
Lord, yes.
Allowed 6 weeks time to file the reply.
When is that matter?
Same order I said.
Same order.
And it can be tagged along with that number.
All that is done.
Grateful, madam.
30.
May I please, your lordship. Lord, appellant is a state discom, Lord. Just have a look at a short note of a few 4 dates, my lord, I have just handed over. Courtmaster?
I'm sorry then. It would have been better had you.
No, it's only a list of dates. Please don't get it adjourned again and again.
Who's getting it adjourned?
I only have only a short note, my lord, which I'm only giving the dates which are already on record, only separately for this issue.
This is difficult.
My lord,
hands over something which is anyway.
a list of dates, sir. If you don't have any objection, I have no problem, my lord. Your lordship may kindly see the issue involved. The state discom, my lord, where under the regulation and PPA, he has to get his tariff determined 6 months prior to commercial operation date. Commercial operation date is in 2010 December. He had to do it 6 months earlier. He doesn't do that. He filed that application in 2018. 2018. And at page 8, my lord, with
That's why the Regulatory Commission gave from 30th of October 19.
19. And what the now appellate commission says paid from 2011, a windfall, my lord. And my lord, the judgment just come to page 8.
Your lordship judgment on.
Admit the appeal. We'll admit the appeal.
No, my lord.
Well, appeal is admitted. Appeal has to be admitted.
If your lordships feel so, yes. 2 or 3 aspects. One is that I approached them in 2012. The commission I approached in 2012. What they did is, what the commission told me is that wait till the capital cost is determined. Power is being supplied, my lord, to 2 states, Haryana and Chhattisgarh. Now, insofar as capital cost of the unit is concerned, it has to be the same for both Chhattisgarh and Haryana. Capital cost is determined, my lord, in 2014. 18. No, thereafter it goes up in appeal before the tribunal. Tribunal decides in 2018. Capital cost. The tariff will have to be determined, my lord. It has to be relatable to the capital cost as well. Capital cost determined in relation to Haryana was adopted, my lord, by Chhattisgarh also. And therefore, they are a party to that. And therefore, in 2018, my lord, I filed this application. It takes 1 year. And therefore, my lord, the carrying cost is determined. The tariff is determined, and then the carrying cost is determined, ordered, my lord, in 2019.
It's only a question of determination from the date of power supply or from the date of quote and
my lord, from 2019 to 2022, carrying cost directly to be paid from 2019 to 2022 has been paid because they have accepted.
So the issue relates to date commencing from 3/10/2019 to what date?
No, 2019 onwards, my lord, it has been paid.
No, my lord,
it's due from 11 to 12.
I understand. From when to 20?
Period is 11 to 12.
2011,
2012.
My lord, 22/6/11 to 1/10/2012. And my lord, what my learned friend is saying about Haryana.
Well,
my lord, 22/6/11.
2012 is it?
Yes.
22/6.
This is a carrying cost.
I'm only giving the date. 22/6/11, 1/10/2012. And my lord, that Haryana example, the application for determination in the present case is filed before the decision in Haryana. Haryana never intervened.
Every electricity matter comes to this quarter. Stakes are so.
No, my lord, ultimately, my lord, this is a money decree. And therefore, my lord, whatever principles your lordships normally apply in the case of a money decree may be applied to this also. That's what I said. Just a moment here.
The payment will be subject to outcome of the petition.
My lord,
how much is that?
My lord, that's what I'm saying.
How much is it?
Yes, my lord, the payment now would be from 2012 to 2019, which is added by the learned appellate tribunal. The money as per commission, which my learned friend also said, as per the commission order that this carrying cost will be paid from 2019 to 22 is already paid, and the principal amount is paid in 2011-12.
It's not the
rupees 285 kilowatt provisionally, which is fixed, which requires you to file an application for determination. 8 years you don't file, and Haryana
carrying cost.
Haryana determination takes place in March 18. You knew that after 2014 there is an order. You filed an application in January 18. Haryana was not dependent. My lord, decision in Haryana was not at all relevant for this.
How much you will pay?
My lord, I have paid the entire thing as per commission.
As per the decree.
My lord, the decree at the commission level, my lord, the decree at the state commission level, giving them, my lord, this carrying cost from 19 to 22 is paid. The principal is paid up to in 2012 itself.
We'll ask to pay 50%.
Yes. Very well, very well.
Appeal admitted subject to the appellant's taking the payment of 50%.
As for the invoice.
The amount payable. Did you raise an invoice?
I have.
My lord, the amount is, my lord, this amount of carrying cost.
Amount payable subject to respondent giving a bank guarantee for the same amount.
My lord, the difference is more than 100 crores for this 2011 to 19.
50%.
71 crores. So 100 crores.
100 would be the difference to be paid.
271 crores.
The rest is paid.
Survival.
Kindly see principal.
50% we gave.
Very grateful, my lord.
50%. Is there? Don't come back with an IA for clarification. No. Listen to us.
Sorry. Yeah.
Appeal admitted. Pending disposal of the appeal, the appellant shall deposit and shall pay.
No, would your lordship consider it?
No, don't again ask for modification. Shall pay 50% of the what? We asked
of the invoice amount.
No, my lord. No. Yes, I'm sorry, my lord. I must.
The demand. Is there any demand?
Yes. 543. Page 543.
My lord, they went. My lord, what they wanted now was that the payment with carrying cost must be paid up to 2025 from 12. They filed an application before the learned appellate tribunal.
What are you saying?
My lord, what I am saying is
the what?
As
71 crores.
50% of what?
Not of the invoice, my lord, the amount which is required to be paid as per the decree of the appellate tribunal. Very well. That's all.
That's what you're
And my
saying.
lord, if your lordship could consider a little less, my lord.
Payable as per the judgment of the
Appellate tribunal.
appellate tribunal.
Very request.
But could it be a little less?
25%.
Subject to the payment of bank guarantee.
Yes, difference is huge, my lord, with two factors which I wanted to. The
50%
amount,
it's over.
my lord, the principal is paid in
You
2000.
are again arguing, or is there any clarification?
No, my lord, there is no plan. Grateful.
May I please, my lords?
It's not payment to be made in 4 weeks, 6 weeks.
Within 4 weeks. 6 weeks, Kalyan.
Yes, my lords. Fraud is vitiated completely, my lords. 2011 sale deed.
Even
Concurrent finding, I know, my lords. My husband's property, partition in the year 1987, is unwell, mentally unstable, my lords. They somehow took him to Chennai, my lords. Thereafter, did all the things, and there's a fraud.
complete evidence. Sorry.
I'm grateful.
May it please, your
One
lordship,
is
my lord.
my contempt for non-compliance of the judgment, my lord. These are, your lordship will
My
reflect.
lord, we have a
that-
small difficulty, my lord. We have no intention
You
of
work
not
it out with your government.
My lord, kindly, my lord, call them here, my lord. We have given a notice.
We will not entertain it, neither contempt nor that.
My contempt, my lord, where will I go?
Implement, I said.
My lord, we'll
All right.
implement, my lord. We are only
Your lordship may record that. And I have
after,
had-
my lord, the counseling took place of
There is sufficient goodwill in the court hall. And we are assured that the judgment will be implemented. Mr. Jyoti Gupta, learned senior counsel,
For the
appearing on behalf of the
board,
on behalf
primary
of the
board.
assisted by Mr. Kunal Chatterjee, would submit that they will discuss with the government to ensure early implementation of the judgment. In this view of the matter, there is no need for us to proceed with the applications.
Just to assist your lordship to make that order a little more stronger, especially since your lordship gave the direction under 142. The earlier direction to complete the process is a direction under 142 to do complete justice between the parties.
Yes.
So
No
therefore,
difficulty. We only have to, my lord, get the government to, my lord, give us a modified vacancy. Identify a modified vacancy because, my lord, these are subject-wise, category-wise.
Oh, wait, we were actually restrained.
my lord, within 6 weeks
from
or
observing some strong.
within
Well,
against the
your lordship may
board,
observe that this.
varied. You change your stand multiple times. Anyway, leave it at that.
Yes, yes, my lord,
All is well.
on that, I'm not, my lord.
no, my lord, within 6 weeks or 8 weeks, my lord.
Yes, your lordship may say that, my lord. Then it will help us.
Within 6 weeks from.
All right, great.
Thank you.
Great.
All of them are dismissed.
My lord, the state
These
is,
observations, all
the state to decide within 6 weeks, my lord, if your lordship is.
I will not say that. State is not.
My lord, I'm.
Give the appointment. It can't decide and then we are again back.
You will implement it. That's it. You persuade the government. You are bound by.
Yes.
All civil authorities are bound by the orders, whether
Yes,
before us or not before us.
No question, my lord. And the state is before your lordship. It is not even as if they are not.
Okay, state is before us. Okay.
Yes. But they.
What do you want us to say?
Their party, their party.
What do you want us to say?
My lord, that they will reorganize the vacancies, my lord. That's all.
State shall take immediate steps for implementation.
Very,
That's
very great.
Perfect.
Great.
And my lord said time limit may be maintained.
6 weeks, they said. 6 weeks.
That's it.
Done.
Fine. We'll do it, my lord. The pattern is clear, my lord. There's no difficulty.
An order makes everyone happy.
Right.
All sides happy.
Correct. No, but the order of the court must be complied. Your lordship, you said 142 to do complete justice. I mean,
No difficulty, my lord. Absolutely no difficulty. We are, my lord, happy to give, my
Long
lord.
arguments on 140.
No, my lord, there are vacancies, more vacancies are rising in
All right,
future. So, my lord, there is no reason
It's an
to.
unfortunate case.
Yes, yes.
Unfortunately.
great.
Thank you.
Grateful, my lords. Deeply grateful.
32. Non-refund of 7,000.
My lord, this transaction does not have.
It's not covered by.
No, my lord, this does not have the color of a time borrowing for money, a debt, a commercial effect of borrowing. This is a development agreement and can't be equated to home buyers, my lords. The cases where your lordship has said that home buyers pay and get the benefit of
I just
lower.
can say that they are super constitutional.
My lords, may I with respect say this? My lord, this
This
is
is a favor we have sent.
no, I know, my lords. My lords, that is why all that I'm saying is I'm a profit-making company. I have
Yes, yes.
19% share in the
Current
Durgapur
findings
airport.
of fact, my lord, if your lordships.
How is security deposit a debt here?
No, no, my lord, my lord, there are clear admissions by him that this was a financing arrangement. I will show, my lord. Please see page 34. Have a look at page 34.
I have to then.
Not one admission. There are 6 admissions. Please have a look at page 34 for a minute.
What is gone in this?
Para 77.
Has notice gone?
No, no, no.
No, my
Fresh
lord,
matter.
no.
Fresh matter. My lord. Please have a look at page 34.
Because I have to show what are the.
Just have a look at page. No, I'm answering the court's question.
I thought it's my petition. All that I'm saying is, I need to show the clauses. Clearly, this is a case where on completion of a project, 50-50 profits to be shared and money to be given from time to time for development.
It's an appeal, no?
Yes.
Appeal admitted.
Lord, may
Only a
point
money
out.
matter. No,
Lord,
okay,
may-
CIRP, there.
Yes.
That this is an admission.
Yeah, why to settle it?
You should not.
Lord, it was
Why to settle
settlement.
it?
For settlement, my lord, there's a separate procedure. Your lordship knows.
Just take over the companies, just.
My lord, they had
I'm not taking over.
19%
I'm the
share in the
financial
Durgapur
creditor.
airport.
I'm the financial creditor. I moved the section 7 application.
That's what I'm saying, miss,
Yeah.
for everything you want the company to be taken over.
My lord,
Right,
management to
right,
be, my lord, IBC process, my lord.
We are happy to sit across, my lord. We are happy to sit across with them.
All that they want is a security deposit to be, what,
And-
can you work it out?
My lords, we can say, and I'll tell you, lords, we had an arbitration prior to 1.5 years prior to the CIRP starting, where one of the declarations we wanted was this is a development agreement. If the
This is not a development agreement. I'm
Just
sorry.
a minute.
This is a financing arrangement.
Just a minute.
There's not a development agreement. My lord, may I just point out? My lord, with great respect, let me point out, my lord, it's covered, my lord. It's covered by your lordship's judgments, my lord, in orator also. Let me show that. Let me show, and please look at page 34. Just give me a minute, my lord. Have a look at page 34.
How is it covered?
My lord, insofar as, my lord, interest is concerned, this court has already taken view on the definition of financial, my lord, claim that, my lord, interest need not be there in the agreement. Interest fee deposit is also financial debt.
It's not my
My lord, that's one. My lord, please see page 34 now. My lord, 5 documents of the other side wherein they have clearly admitted, my lord, that this is a financing arrangement. This is not a development agreement.
Maybe right, we might dismiss it.
My lord,
But anyway, we will examine.
grateful, my lord. If your lordships admit it, my lord, it will not come up, my lord. That's the problem. It will not come up, my lord.
You argued so many cases and then we have given judgment.
Yes.
also.
My lord, so many matters come up.
No, I'm saying
that what is admitted
unless
never
your
comes up.
lordship, no, my lord, unless your lordship gives a fixed date, my lord, it will not come up. Your lordship knows, my lord.
It up in the final hearing list in the month of February 2027.
Grateful, my lord. Very grateful.
We are putting it in the final hearing. list.
November, my lord, or December.
Okay, end of January 2027.
Grateful.
So what is it?
Please, my lord, your lordship.
Right, thank you. Then we'll do it in the December.
December,
November.
November, my lord. Grateful, November.
Yeah.
My lord, this can be even on a
Give us the
Wednesday.
compilation of that judgment, sir.
Yeah, I'll do that. My lord, I'll give a compilation. My lord, can I just point out, because it's a statutory appeal, your lordship, it can be even on a Wednesday, my lord.
Leave it alone. Nothing will happen.
So,
I was on a Friday, my lord, and trying to sleep both of us alone.
so, my lord, your lordships have said November, my lord. Very
Grateful.
lordship.
As per the letter.
Next week, Miller, because I am not in difficult, Miller.
What?
Miller, they are selling. They are.
Listen,
They have circulated a letter, Miller.
Interim order, why should we? Earlier, 33.
They have circulated a letter, Miller.
Interim order to put, no?
That's a reverse by High Court. No, Miller, I'm sorry, Miller. Again, the very compromise decree between the parties. Lord,
Sir, you argue by now what? The appellate
Your Lordship may have it next week.
January 24.
They have, Lord, they have their portions, they have already sold, my Lord. They're under the compromise, there are certain portions allotted to me.
There is an interim order in the Supreme Court for you.
Lord, your Lordships have heard me, my Lord, for some time. Then your Lordship sent it to mediation. My Lord, mediation failed. There is, in the meanwhile, my Lord, they have executed sale deed after sale deed. Lord, I will argue it
The
next
letter circulated. Next week.
Very well.
Grateful, my lord.
34.
Please, Your Lordship. Lordship, we had to urgently move this petition by way of mentioning Your Lordship was in the Constitution bench. Lordship, Lordship, notice has been issued, services complete, but none of the respondents have appeared.
Amendment of pleadings.
Yes, Lordship.
Joint owners.
Lordship,
Courts have dismissed that application. What is there for us to interfere?
Lordship, the High Court had dismissed the application. Lordship, may I kindly point towards.
What is there for us to interfere in this?
Lordship, I can't.
What do you want us to do? It's an interim order for amendment of the pleadings. Both courts have rejected.
Both courts, Lordship, may I kindly show the High Court observation? The High Court says that change of counsel is not a ground for amendment.
Anyway, your application is what? Suit is of 2013.
Lordship, suit is
And this application is filed in 2021 for amendment of pleadings.
Lordship, we filed it in 2021 when only one witness has been examined.
Whatever witness.
Then, Your Lordship, when we came to the High Court, the observation was that.
Amendment of pleading, both the courts have said you have enough.
Lordship, today the situation is this, that the case has been put in the fast track court. This amendment of pleading is necessary for the decision of the suit, Your Lordship. And now it was listed for final hearing, post which we had to urgently mention.
Operates, huh? Operates. They can't do it. Dismissed. Trial has come.
Lordship, we had also filed an, the proviso is covered in my humble submission, Your Lordship. It is covered by the exception, Lordship. We had only moved the early hearing application, Lordship.
You can raise it in appeal, interim order if you want. And due diligence, we took that due diligence.
And we had also taken the due diligence, Your Lordship. 1 second. The only witness here is a 103-year-old person, Your Lordship. One second.
Dismissed. Next.
Your Lordship, the application.
Provisional affiliation you want without payment of the fees. Item?
35. Application. This is an application. Your Honor, petitioner is a school which is run by the retired army officer, free school, providing free education, books and uniform to all the students.
How much is that amount?
And they are asking for 1 lakh.
Is there a provision for getting affiliation without payment of fees?
No, Your Honor, the rules do not provide for any of this thing, such of fees, because they have there is no power in the act. All the schools, boards in the India, nobody charges 8 or 10,000 more than this. They have suddenly from 30,000 come to 1.67 lakh. Suddenly last year it was this much. They have come to this much now.
File a counter.
Milord, we've not filed the
Bring on record all the rules.
Yes, Milord, they're already there.
Why are you charging so much for affiliation?
Milord, that's for 3-year periods, but there's another problem. Milord, there's another problem. His students are today.
30,000 has become 1,000.
Yes, Milord.
When did they apply before the amendment?
There have been 2 amendments.
When is the amendment?
Yes, Milord.
2023.
Milord, the first one
That is in page 61, Your Honor.
Here, Milord, this was 27th October 2023, where the application fee, Milord, was 30,000.
1.5.
Then, Milord, kindly see P10, page 108.
Half of the money would have been spent in litigation only.
And Milord, there's a deeper issue.
Litigating for so long, but you are not willing to pay the affiliation.
There were only.
But that's applicable to everybody.
Your Honor, that's not the question. Because the question is the act does not authorize them. It is only state government which can levy the fees, not the board. And these are all the school, but there are no CBSE thing.
This affiliation
and
fee
last
is a red herring.
You know, page
Kindly
62.
see the order at P5, page 29.
Yeah, what exactly is he troubled with? I don't know. There's something more than what.
Yes, my lord, he's moved the court in several rounds. On the last occasion,
he is willing to spend lakhs of rupees on litigation.
Not Your Honor.
Argument.
No.
Which page?
Page 29. At the bottom, my lord, he raised an argument that our rules say that for class 10, you should apply for affiliation when your students are in class 9. he raised an argument, I am not being clearly informed on what date this should happen. So, my lord, we gave instructions at page 30 that when your students are in class 9, apply it till the window of 15 September 2024. He expresses satisfaction with that and the petition is disposed of. He doesn't apply under that. So, my lord, he files the second writ.
Why are you fighting all this?
Your Honor, just for a moment, just for a moment.
Just tell us.
I came to the, earlier they said, as per the regulation, they
What exactly is your grievance, sir?
three grievance. Number one, they were asking 5th and 8th class examinations. The RTA Act says you cannot have. I say, if you want to have examination, you can have examination without any fees from the student. We have no problem with that. That is against the RTA Act. And now, second, when I want
board, right? It's not a private company.
your CBSE, etc., they do not conduct an examination of 5th and 8th one.
In the country, it's not just for you.
No, even in other states, there is no examination of 5th and 8th one. That beside the point, Your Honor. That beside the point.
Policy issue.
That beside the point. Because now then they said the affiliation will be from middle to senior secondary onwards. But subsequently, after my first interpretation, they amended the rule to say the affiliation will be from metric onwards. So when they came to the metric, Your Honor, just
Last point.
just the same. Since this is all just student done on the only donation of the retired army officer professors, no fees is being charged. Children, the mothers of all the children are housemates. So that is for poor purpose that was started. Kindly grant me this time I pay pending the final hearing.
It's not a private transaction. It's the rules which govern the fee.
If there, Your Honor, if Your Honor finally come to rule that they can levy me, I will pay that also provisionally.
Provision for exemption.
There is no, they are not charging from any government school. They are not charging from any affiliated school. They are not charging from associated schools.
You are not any of those categories. So therefore you have to pay.
Your Honor, permit me, Your Honor.
Read the rules.
Yeah,
Just
for a moment. Permit me this time that I will pay and keep it pending. Finally, hear it, Your Honor. Keep this pending. Kindly this thing. Because I will be otherwise remediless because of this thing.
Thank you.
You're one relief for you. My last date is 15. Let they give me some time.
Apply and take it. Don't unnecessarily litigate. Next.
May it please the Lords. On 28th of February 2025, Your Lordships had issued notice and stayed the operation of the impugned judgment because the High Court, my Lords, had interfered with the seniority list of the year 2001 and 2025, my Lords. Lords, thereafter what happens is the petitioner number 2, my Lords, becomes eligible, my Lords, for promotion to the post of section officer. But now the promotion is not being done, my Lords, on the pretext there is an interim order in my favor. I would just request Your Lordships to please clarify that during the pendency of the proceedings, subject to the outcome, whatever the outcome is, my Lords, I at least should get promoted, my Lords, because at the end of the day, there is an interim order in my favor today, my Lords. I don't have any difficulty with my senior colleague's suggestion.
What? We are not able to follow anything.
My Lords, I'm so sorry. My Lords,
In the main matter,
my Lords, may I open my case, my Lords, if my senior colleague doesn't?
Wait. Tell us.
My Lords, yes, I'm so grateful. My Lords, Your Lordships had entertained my petition, my Lords, and on 28th of February 2025, while issuing notice, had stated...
A little background.
Yes, my Lords, I'll just tell Your Lordships. My Lords, these are...
Section of clerks, sir.
Yes, my Lords. What had happened was in February of 2001, my Lords, there was a selection of 9 persons, my Lords, for clerks, for the post of clerks.
That's marks in...
Yes, my Lords. My Lords,
the seniority list was made.
Yes, my Lords, the seniority list is
made in
2001. Yes.
Later on, he came to know that he's actually good marks.
The story he sets up is that I found these marks.
It's a fact.
My Lords, the writ petition, government...
It was allowed.
Yes, writ is allowed on the ground that he...
Then your matter was dismissed.
My Lords, my matter gets dismissed. Your Lordships are kind enough. My Lords, Your Lordship issued notice for 2 reasons, my Lords. One is the reply which was filed by the Public Service Commission, which disputed the mark sheet and said it's a fraud by him and there's a forgery by him, and asked the High Court to initiate prosecution. That is a reply which the Public Service Commission, who conducted the entire exercise, has filed on oath. No. My Lords, in the High Court, the reply in the High Court is the same which the reply now before Your Lordships is the same. Not considered, my Lords, and the reply before Your Lordships today is the same by the respondent number 2, saying that these are all forged and fabricated records. Because what happens, my lords, is that in the year 2001, this particular gentleman...
saying that this man's contention that he got better marks than you is all by way of a fraud.
Yes, my lords, I am so grateful. That is the reply of the Public Service Commission disputing his conduct. No, the reply was before your lordships today.
This submission is
Lords, I'll just tell your lordships.
Is anybody appearing for the public service?
My lords, they filed a reply and...
Service Commission party here.
Yes, my lords. Mr. Bhupinder S. Chauhan.
Milord, it is. Your Lordship, I am for Vidhan Sabha. There is no public service commission.
I'm sorry, the Vidhan Sabha. The Vidhan Sabha. I'm
There is
sorry.
no public.
The Vidhan Sabha.
There is
Yes.
no public service
The
commission.
Vidhan Sabha has
Election has
It
been
is
made.
Himachal Pradesh Vidhan Sabha, Milord.
Vidhan Sabha has supported
Indian
us.
Council is appearing for online politics.
If your lordship will kindly see just 3 pages.
Mr. Patwalya, 1 minute.
And this fraud is by him. Single judge called for the records. He has returned a finding which is confirmed by the division bench. Please have page 146.
1 minute. Himachal Vidhan Sabha.
Himachal
This selection is for Vidhan Sabha.
Yes, I'm so grateful. Please see the reply which is filed, my lords, before your lordships today.
Please have through 2 pages.
My
Please have.
lords, what happens is, my lords, the High Court has noted that condition but not adverted to it at all. That is the stand on oath before the High Court. I can show the reply, my lords, which they filed before the High Court.
Says about this Vidhan Sabha stand.
My lords, your lordship will note the single judge's order, my lords.
At 146 para 40.
Please have a look at the single judge, my lords.
Right, we can't do this fact-finding inquiry.
Page 150.
Just in this case, there
150?
My lords, the annexure P13 at page, my lords, 139. Please see his case, my lords, where at 143, his contention is recorded at page 143, paragraph 10. That the copy, may I read that, my lords? The bottom of page 143, para 10, the copy of the mark sheets found by the petitioner in the corridor of the office has been placed on record. So he says that he discovered these new mark sheets in the corridor of the office where he was working. No, that's the recording before the High Court, my lords. And then your lordship will see the stand of the Vidhan Sabha at page 144, para 11.
Okay, you go to the High Court.
Lord, just have.
We are not inclined to interfere with the order passed by the High Court. With respect to the submission of Mr. Abhinav Mukherjee, that the Vidhan Sabha has taken a different stand. His client will be entitled to file a review petition. While we have not expressed any opinion on the merits of the matter, it is for the High Court to consider and dispose of the review petition on its own merits.
May I request one more indulgence, my lords? There was an interim order which your lordships passed because the direction of the single judges to recalculate. When your lordship has stayed the impugned judgment. Why? Because the single judges passed an order directing the Vidhan Sabha to recalculate the seniority fixed in 2001 in 2025 against the settled law, my lords.
Necessary.
My lords, your lordship will just, in the meanwhile, protect me, my lords, while I approach the High Court.
Please,
Within a week, my lords.
Please give me 5 minutes. Lord. Even this is not required.
Manner, Abhinav, you impressed us to issue notice.
My lords, I hope the same impression would have been carried forward today, my lords, but I think Mr. Patwalya is more impressive today.
Please see page 140.
My lords, please see, my lords, just that indulgence, my lords, that 1 week at least should be granted to me. I'll file that and then let the High Court take a view in the matter, my lords.
Would be proper.
My lords, let the High Court take an independent view at least in that, my lords.
You have to impress the High Court first on your.
My lords, please do consider it. There was an interim order in my favor right from the time of February till now, my lords. We are in September. Otherwise, the directions will come into operation immediately. The direction is to recalculate and refix seniority from 2001 onwards, my lords. In 2025, the High Court has passed that direction.
No, Abhinav, you will not.
Please consider it, my lords. That's my request.
Till the High Court takes up, shall we give them status?
No, my lord, no.
No,
Please see-
status quo at least.
No, my lord. Just see page 146. Your lordship may see 2 paragraphs of the single judge and 2 paragraphs of the division bench.
What?
Page 146.
What? Tell us.
Yes. During the pendency of the petition, this court requisitioned the original record from respondent number 1. Petitioner's relative, more particularly the final score sheet.
Thank you.
Yes.
Status quo till then, my lords.
37.
You know, 135, permit me to withdraw that one. 135.
Because then I have the liberty to come back again in case my review is dismissed. That's the only indulgence. Otherwise, I will be stopped from challenging it.
You have.
Because please at least make that observation. Yes.
Review as well as the main order.
Permit to withdraw.
If advised.
I am so grateful. In case it's against me, my lord.
May it please your lordships. Readings are complete in 37.
Now, Lordship,
What is this, Manish?
yes, Lordship, this is about it's a tender,
Statutory auditor.
statutory auditor. Everything depends.
There's become infractions, my lord.
There's nothing infractions.
It has been completed, report filed, next year's
Lordship.
report has come.
What is it that you're challenging here?
Yes, we are challenging the very, we should have got it. That is what, that is when Lordships.
No, nothing in this.
Now, Lordship will then,
Dismiss.
Lordship will then give me one liberty.
Keep the question of law open.
No, I'm not. There is a question. If today Lordship doesn't want to entertain.
What do you want?
Now, Lordship, Lordship has recently, in your Lordship's own judgment, in Manoj, has said if ultimately there has been something wrong, I have a right to restitution. Can I be at least given a liberty to file a suit, and this will not stand in the way, this dismissal, because your Lordship is not commenting on the merits?
Public law proceedings, where is the question of a suit?
No, suit.
It's a tender.
If I have been wronged, if because that is what Lordships had, a prima facie view.
All right. Okay.
Then at least to that extent,
Nothing, there's nothing in this.
if I can at least be
That's a different matter.
grateful.
Next.
Grateful.
Very well, Lordships.
Wait, please, my lord. My lord, here the yes, my lord. My lord, here, my lord, the High Court at last year will recall on the last occasion they took time for counter. My lord, this matter will have to be allowed because the state election. I'm sorry.
My lord, my counter is already.
Yeah, that's right.
On behalf of.
Lord, what has happened here is.
This is against the interim order.
Yes, my lord.
Yes, my lord.
The interim order has been passed after the election process has begun. So your lordship stayed the interim order.
No, my lord.
After the yes, my lord. This matter,
Lord,
the order can be confirmed. Writ petition can be decided on its own merits, my lord.
Process started way back in September 2024, my lord. This was only a rescheduling of the earlier election notification. This is an admitted position, my lord.
Confirm that interim order.
Yes, ma'am.
And ask that
High Court may decide
to dispose of the writ petition.
Interim order of the High Court.
By our order.
My lords, this is only an interim order. The main petition is still pending. The vires of the amended Rule 12B is still pending. He is coming for the first time before the Honorable Court, trying his luck here, while he's been sitting on the,
Well, I have been
in the High Court in two writ petitions, my lord. Both are pending.
Were already conducted under the new rules.
No, my lord.
Lord, may I just give the dates now?
No, my lord. With great respect.
High Court in Division Bench says that hold under the old rules. Is that right or wrong?
Lords, no, that is wrong, my lord. The first election was notified on 12/9/2024. Thereafter, the amendment was brought about in Rule 12B, expanding the electoral role in 12/12/2024. After that, there has been a rescheduling of the earlier notification of the election on 25/1/2025. By virtue of that, Rule 12B, he is coming.
So elections were rescheduled on 25/1/2025.
Yes.
And when they were rescheduled, whether it should be conducted as per the amendment of 12/12/2024 or earlier is the question.
Please, my lords, grateful. That is the only issue
My lord, by the time, my lords,
which is being agitated in this SL.
Then the election notification was 2024.
Grateful, my lord. Yes.
So elections were in fact conducted according to you under the new rules itself.
Results were.
My lords, the new rules are coming after the election has been notified. That is an admitted position by them. Kindly see 102 page. That is the single judge order of the High Court. They have admitted this, that the rules were notified, that the election was notified.
What saying is that the new rules in December 2024 came after the notification in September 24. So therefore, only
The new rule is followed in 12/12/24. And the notification is 25/1/25.
25?
25/1/25 is the notification by virtue by which he is taking benefit from. So the amended rule came prior to that, and the main notification is in September 2024. So election process was already rolling. It had already started, and that's an admitted position by the state as well as the election tribunal at page 102 of the single judge order of the High Court.
They conduct existing. No, already elections hold kar chuka hai. By which
Lord, results were already declared, my lord.
No, my lord.
Lords, kindly have a look at.
What he said last time.
Lords, page 80,
No, my
if your
lord.
lordships have. Just one second.
Declared,
My learned friend.
but he is trying to take benefit of the rule, which is already, the vires of which is already pending before the Honorable High Court. He's not assisted the High Court. He's jumping here in the Supreme Court for the first time.
25th January 2025 are challenged before the High Court.
No, no.
The virus is challenged.
No, no.
You're saying virus is challenged.
Virus of the amendment, my lord. A virus of the amendment has been challenged and it is still pending.
12th December 24. Is it?
Yes, my lord. 12/12/24 amendment is still, and he is taking the benefit of this amendment only over here. My lord, may I be allowed to read?
The only difficulty is that the elections are already held.
No, my lord. Even this notification has been set aside. There has been a subsequent notification after this in March 2025. Even that has been stayed.
Who are you appearing for?
I am for R2, my lord. My counter is there. I have placed all this on the record in my counter affidavit. R2
D.El.Ed petitioner, my lord.
is the petitioner in the High Court, my lord.
Who is appearing for the
Election Commission, my lord.
My lord, I appear for the election authority. My lord, your lordship will kindly see.
Have you filed a
Yeah, my lord, I filed my counter, my lord. I filed my counter stating, my lord, all the reasons, my lord.
What's the
Your lordship
petition?
will
Are you
kindly
supporting
appreciate.
the petitioner?
Your lordship will kindly appreciate, my lord, that in 2023 there was a membership drive to increase the membership, and my lord, it resulted in
We just take
nearly
stock of
1
the
lakh
fact.
addition of new members.
We go through your affidavit.
My lord, my affidavit is on record, my lord.
Affidavit of Election Commission, no?
Oh.
Which item was that? 30?
38. 38.
My lord, of the total 6,379 seats.
Next week, come next week, we'll decide.
My lord, may I just, lordship may have it next week, my lord, just 130 seconds, my lord. My lord, what has happened here is, my lord, the results were already declared, my learned friend is here.
We've gone by your statement, we'll study and come back.
Yes.
We didn't see the counter affidavit.
Very well.
We'll take it.
Counter affidavit of the Election Commission, para 6 to 11, my lord.
See that?
Yes, my lord. Next Friday, my lord.
My lords, we kindly have it on a non-miscellaneous day.
We'll see. First of all, we'll be satisfied, then we'll see.
Lord, in fact, my lord,
They are still at the stage of admission, we might even dismiss it.
Grateful, my lord.
my lord, in fact, my lord, the elections happened, my lord, way back in 23. And my lords, now, my lord, there is no head to man these committees, my lord. That's why we are requesting.
Lord, they're not coming with clean hands. Even this notification has been set aside.
Friday, we have given it next
Great.
Friday.
Grateful.
Grateful.
Obliged.
Lordship, this matter is relating to compassionate appointment. Yes. Yes, Your Lordship, it's completely covered by a 3-judge bench decision of the very same High Court. Sorry?
Which judgment did get covered?
Yes, Your Lordship will please have that judgment. We have annexed it at page 18. It specifically referred to a 3-judge bench on this very point. Kalpana versus State of Maharashtra. Your Lordship will please have the relevant portion.
Bench of this court?
No. Bombay High Court.
What does it say?
Yes. Your Lordship will have page 44, para 27 onwards. It says that while the application is pending consideration, it is for the family to decide. And if they want to substitute one of their family members with another family member for compassionate appointment, that has to be worked. Sorry?
You got your brother has already.
Yes, but Lordships, the problem is he is still completing his bachelor's. My sister, who is elder to me, has already completed her entire education, and we applied to have the name replaced while our application.
When did you apply?
Yes, please have that date. I have initially applied, that's at P3, 30th August. And then, your Lordships will see, I asked for substituting it, P3. Page 114, 30th August 2024, while the application was still pending consideration. And in fact, after your Lordships issued notice, your Lordship said in 5th May, have it immediately after 2 weeks so that we can do the needful. Now, the application process, I am informed that they have issued appointment orders, but we are still interested. So your Lordships may say,
orders to whom?
The brother has been appointed, Lordship.
Appointment order has been issued. I have taken instructions. Your Lordships may say in accordance with the judgment, if he can still have the sister completely covered. And please see the impugned judgment.
Judgment is different. It
No.
that in that, may I submit, Lordship? In that matter, the candidate who was on the wait list was waitlisted for 13 years and he was attaining 45 years. At that time, the court considered that this they will lose the precious right for compassionate appointment is when they allowed the substitution. As per the GO which was applicable to this case and to that case also, there is no provision for substitution unless the candidate is expires while he's in the wait list. Now,
Appointment to the son came in October 24, no?
yes, Lordship. And the position was
Did the son
declared.
get appointed anyway?
No, he got appointed now, just now, 2 weeks ago.
Lordship, the appointment order is on record, Lordship. It's on page 152 at 156.
Date.
Date is 8th of October 2024.
Lordship, that was not the final conclusion. They continued this process for so many years.
October 24.
Yes, Lordship.
Who appointed?
It's on page 152.
That way the purpose is served.
That's not correct, Your Lordship. When Lordships issued notice, I informed Your Lordship the appointment order is still in process. And Lordship, I must say, this is a... She has completed her complete education. He would have to leave his undergraduate.
Lordship.
Sorry?
The
Yes.
judgment.
That is a completely incorrect statement. It's not nothing.
Oh, that judge.
Yes, judgment. Kalpana. That is, Your Lordship will have, I have annexed it at page 18 and Your Lordship will please have. May I just show Your Lordship, the very same para which is relied on by the other side is actually considered.
Kalpana, has it come to this court?
No, it has not. It has not been challenged. It's been accepted by them. Please have para 12 onwards.
What fell for consideration in Kalpana?
Yes.
That seems to be a whole batch of men.
Yes, that's what it was on a point of law. This is a completely incorrect statement. It was not on the facts of that case at all. And this is precisely the very same paragraph which was considered.
The point,
No, now let me
question of law was that if the person is attaining 45 is when that it should be considered. There's a fresh GO that has been passed in July 17th.
Yeah. Yes. Lordships will please see paragraph 3. They have considered various differing decisions. This very same paragraph which now is being told to your Lordships that it's
So
only...
the relevant operative portion.
Yes, operative.
54, is it? 54.
Yes. Please have para at 26. Para 26 at page 44 onwards.
Page 54,
No, come to
para
54.
51. Yes.
54.
Page 54.
Lordship.
Yes, I'm so grateful. In fact, your Lordships will please see page 50 above. No, please see page 50. Because they have given certain examples and my case is exactly covered in that example and I pointed that out to the High Court. Please have page 50 for a minute before your Lordships go to page 50.
That's not the ratio. Lord.
Page 50, para 41. It may be noted, there may be a number of reasons justifying the request for substitution of name in consonance with the object of compassionate employment. Though it is difficult to anticipate every such situation, few are stated here under as illustrations. And please have illustration number
All right.
Illustration number 3 is exactly my case.
All right. Does the operative portions question of considering the object of compassionate modeling to provide the mediation. Somebody who dies in the harness as expected to want automation. Whether you taken in, that's not relevant.
Question number
The policies of the state which provide the
2A and B.
substitution, even on account of crossing a particular age, maintaining the interest of the candidates for compassionate appointment is not contrary to it. But that's not, where is the finding with respect to
Sir
substitution?
B, Lordship B, page 50.
Para 42, page 51.
On the name of another member in place of a member who has applied
On account of crossing the age limit.
is not contrary to it. Oh, that is in case of a crossing of 45 can be done.
That's what.
If somebody is already 45, you can get him substituted by some other member.
Lordship.
But then if son is given, do you have the choice that instead of son, I will send that?
Yes, and
Lordship, there is
and
no choice as per the GO.
3-judge bench. Lordship, this is completely incorrect. Please, then let me take your Lordships through the judgment. Your Lordships will please have the relevant provisions which are considered para 18, page 40. This very provision has been considered and interpreted by the 3-judge bench because of differing judgments where they have said that if the application is still pending, it is up to the family to decide who should get compassionate appointment. No prejudice is being caused to them.
We understand. Choose the
Lordship.
Go to the judgment, looks like that it permits.
Yes,
Direct-
para 18, that very...
I will show the GR also on this.
There are two more things that there is a submission.
Yes.
The 2 GOs have come into existence.
Lordship, I have them.
And even as per the 2 GOs, he will be entitled
Lordship,
to.
that in that GO, in that GO,
July.
it's applicable from July, Lordship, July of this year. And she has already.
Give them a copy.
I will give it to her.
Copies of those 2 GOs because earlier We've seen that those GOs benefit them.
Lordship, they
Look at those two.
Lordship, I'll give it to her, but this case is not covered by that because
We'll argue it on Tuesday.
This
Go
Tuesday,
through
Your
those two
Lordship.
GOs, huh?
Yes.
Lord, this matter, your lordship said indicated will have to be heard.
40.
Yes, the reason is this. Lord, I am a highway contractor. Now, Lord, disputes arose, NHAI is terminated. There were 3 arbitrators, Lord, retired judges of the Supreme Court. They passed, Lord, a section 17 case that, Lord, escrow amount should be deposited.
Be heard.
No, only one.
This will have to be heard, my lord. The suit,
Correct.
the claim is allowed at an 17 stage, my lord.
Correct. So, your lordship said we'll have to decide, my lord, whether the new amendment, my lord.
Why is it coming after?
I'll tell you, my lord.
such a long
I will tell you. My lord, I have filed an IA for the reason that pending all this, the High Court has terminated my contract and said you can get 0. It set aside an award, my lord, of 3 orders, 3 judges of the Supreme Court.
Not award, it's an order.
Enforceable. Now, my lord, Canara Bank has filed, my lord, a resolution, my lord, application against us, CIRP. Now, my lord, if the CIRP goes through, my lord, we'll be finished. Nothing will remain here. So, I have filed an IA that, my lord, CIRP may be deferred for a month or 2 till the lordship decide.
No, that's an entirely different issue.
My lords, I appear for Canara Bank. We are opposing this, my lords.
CIRP should arise out of CIRP proceedings.
Yes,
CIRP,
this is completely a different
CIRP has been started against us. I have lost, my lord, in the High Court. I succeeded before 3 arbitrators. If the arbitrators' award is restored, there won't be any CIRP. Because I am.
My lords, I appear for Canara Bank. We have nothing to do with this arbitration.
It's a vicious circle.
What can you do if you get such a bad order? What can you do? High Court has by speaking order. Lord,
So I'm saying either stay the order, or if your lordship not staying the order, at least not defer a civil death.
Allow me to show.
Why should you not
Remind your lordships.
How can my
Without
friend
a
say, my lord,
statement
the
of
order?
claim,
Sorry.
without a statement
I
of
have
claim,
filed, my lord, an IA saying, my lord, pending this, either, my lord, your lordship may consider granting a stay of the High Court's order, or at least defer, my lord,
that
a
is
civil death.
refused.
What will remain in this case if the third party rights will intervene, resolution plans will be there, COC, my lord, will come, what will remain there?
Just recapitulate to us.
I'll tell you. So, my lord,
My lord, I'll file my reply, my lord. I have just received it. My lord, it might take time. My lord, this is something, my lord, unheard of.
Either,
Even
my lord,
the order
either
is
I will
unheard
argue
of.
it, my lord.
I rarely, my lord, use this word.
How
the
does it
order
affect my
of
learned
the
friend?
arbitral tribunal is unheard of
Just 1 minute, please.
and rightly set
No, he's
aside by
appealing for
the
NHAI. I'm wanting relief against Canara Bank, not NHAI. Yes.
That we pass an interim order against Canara Bank in a CIRP proceeding is something which is very difficult.
I have joined them here, my lord.
That CIRP against that order you will have to come, not in an arbitration matter.
My lord, kindly see. My lord, CIRP has been commenced on account of the fact that the High Court has passed an order against me and squeezed my finance. As long as my finance was there.
Come on Monday.
All right. Yes, I'll come on
Yes,
Monday.
yes, my lord, we will address your losses.
Yes, your lordship, I hear it on Monday. No problem.
Come on Monday.
Yeah. Lordship. And I'll show you, my lord, just 5 minutes back, I got an identical order from court 2 in another case. Identical.
Get that. Give a copy.
And I'll also show, my lord, why.
My friend was there. My learned friend was there.
He will show an identical.
No, that was
No,
not
he was
identical.
there, my lord, opposing me in court 2.
Mr. Rodgi, that was CIRP proceedings. There was no arbitration.
Monday
My lord, your lordships may record this, that it is an identical case.
Okay, we'll come back.
It's not really funny, my lord. But, my lord, I will also show why the central government had to take a decision not to go in for arbitration.
All right, Monday.
Thank you very much.
For the respondent.
40?
Yeah.
Yes.
Lord, this is the matter where the on-the-spot checking, my lord, found that there was adulteration in fact going on.
So you're saying the guidelines won't apply for adulteration?
Exactly, because our contract provides for termination.
Guidelines, first of all, my lord, it is not correct that adulteration was going on. The finding
are these the same guidelines for adulteration?
For adulteration also, it specifically says even in the case of adulteration, I'll just show the guidelines straight away. I filed the
even in case of adulteration.
Even please have the guidelines as were effective as on that date in my counter statement.
There in case clause 9.
Yes, please have, my lords, my counter affidavit.
So only can I, my lord, is responded, my lord, I just refresh your lordship's memory.
We only want to know that even with respect to adulteration, same termination clause will apply.
First instance, yes.
Yes, page 82, my lord, that is our contract. Page 82, that is our contract, my lord. It cannot, guidelines cannot override a intra-party contract.
42.
Lord, and here, my lord, the spurious material was found, Lord, octane or something, my lord, which is
solvent naphtha.
solvent, my lord, solvent naphtha. It was being downloaded, my lord, in the underground tank. It was caught red-handed. And please see, my lord, if the dealer shall, my lord, your lordships are at page 82.
Yes, read.
If the dealer shall either by himself or by his servants or agents commit or suffer to be committed any act which, in the opinion of the executive director of the corporation for the time being in Madras, whose decision shall be final, is prejudicial to the interest or good name of the corporation or its products, the executive director shall not be bound to give reasons for such decision. My lord, thereafter, my lord, please see the power of the termination. Yes, my lord, it is, I'm sorry. This is the termination, my lord. These are the conditions for termination.
To the contrary, you see it at page number 9.
No, page 79 first, my lord, if your lordships don't mind. I'm sorry, my lord, I went to 82, my lord, a little fast. Page 79.
Yes.
Page 79, clause 56 of the contract, my lord.
Yes.
Notwithstanding anything to the contrary herein contained, the corporation shall be at liberty to terminate this agreement forthwith upon or at any time after happening of any of the following events. And the event which I had read, my lord, at page 82 is one of the events. Now, my lord, what happened is, my lord, at page 241, 242. Okay. Please kindly come to page 241. This is the finding, my lord.
What is this? What's that? 240.
241, my lord, is the first appellate court's finding. Upholding, my lord, the original order. Para 16, my lords, have. Para 16, your lordships have, my lord. Page 241.
We will hear it. These clauses have to be seen.
Well,
Whether there is in cases of
this
adulterating feature, whether it should be as per the guidelines.
Well, it's there in the guidelines and it has been decided by your lordships earlier. In fact, there are judgments, 3 judgments. I'll show. In fact, before the Allahabad High Court, the petitioner herein was a party. It has accepted the judgment that the marketing guidelines will have to be applied.
It's very difficult to say that when there is a clear case of adulteration.
Well, the guidelines deal with adulteration. The guidelines deal with adulteration.
Tuesday ka date with them.
Some early date because
We'll give you a date. It's a non-miscellaneous date. 42.
Great.
42, I had succeeded up to 30.
What happened? Who is there?
Yes, affidavit already filed. It's order your last directions have been complied with.
No, but they have filed an affidavit saying that I can be paid. Now, what the trial court says is, you give one surety, one security. I'll never be able to do it. I filed that additional document.
You should give Mr. Patwalia. I'm just
No, but your lordship.
Apply with that 42.
Pardon me?
Some surety you give.
No, he says furnish.
Small amount.
No, he says furnish indemnity bonds with one surety. My lord, indemnity bonds, we will have to give a bank guarantee for that.
Indemnity bond you can give, but some security.
And
some security.
What we can do is we will give security of the same adjoining land, my lord, as per the award, which may be at the same rate.
Submit, my lord. At least in 400 connected matters, your lordships have given direction 50% release subject to furnishing bank guarantee of a nationalized bank.
We are not going to review our order.
No, I'm not saying that.
There is no order here of any bank guarantee.
Order.
He does now. He's trying to overdo it. He came, tried to get it reviewed. Your lordship rejected the review. And now, my lord,
79 millet. PDF page 79. Relevant paragraphs 7 and 8 millet.
Para 7, my lord.
Before your lordship's
Just one.
directions, we have deposited entire amount.
So therefore, then my friend should not.
Yes, correct. 9/8/24.
Just 1 minute.
Page number, just tell us.
Millet.
Page number?
Yeah, millet. It's relevant
Page 81.
Paragraph 7.
Just 1 minute. Page 81 from the top, my lord. If your lordship will have.
1 minute, I'm not able to get it.
That is para 8, just above para 8.
What's the page for us?
79.
No. These are the counters.
It is in the form of an affidavit.
Yes, yes. He says affidavit of respondent number 1 in response to the contempt petition. And
There are no page numbers there, affidavit.
79 in PDF page.
Internal page 3. Internal page 3. This is the 5th line from the top.
Yes, tell us.
To facilitate payment, an amount of 4 crore 82 lakh has been deposited with the executing court on 9th August 24 and earmarked towards satisfaction of the decree and compliance of the directions of this court. Deponent has furnished a separate affidavit before the executing court requesting the court to release the amount. They don't even ask for security from the funds already deposited in accordance with the calculation sheet provided. And then the balance is in the next para. Again, if your lordship will see further, the deponent has filed
An affidavit.
that affidavit I have.
Mr.
Pardon me?
Priyanka Meena.
Yes.
Priyanka Meena, who is a project director, NHAI, has been filed. The relevant portion of the said affidavit is as under. Quote it from paragraph 7, 8, 8 and 8. In view of the affidavit, there is no need to proceed any further with the contempt petition. Contempt petition is disposed of.
Your lordship may say, let the amount be released on giving security of the same land, because otherwise it will never come to me. Because if he says, now
land means what?
Adjoining land, they have acquired this land to make a road. The adjoining land also belongs to me. I have about 11 acres and all.
They are asking you to provide security.
No, what he wants now is.
There is no such direction there.
Yes, there is no such. He says give indemnity bond and one surety. Now, if I have to give an indemnity bond, I will have to get a fixed deposit from a bank. This man will never be able to get it. It's about 15 crores, which.
How much is the money?
It's about 15. It's about total about 20 crores has to come. And the total amount is 45 crores. These are, my lord, all agriculturists and landholders. In fact, now what my friend is saying, that order is subject matter of challenge before this court. But in this case, your lordship never said any bank guarantee or anything. He can't now add to it. I'll never get the money. And my friend is already saying.
Patwalia, you are asking us to correct the order in the execution petition. That is a different matter. They have complied with it. There is substantial.
No, your lordship may have page 23.
I'm not going to do anything more.
Page 23, your lordship.
So far as the compliance is concerned, there is a amount is deposited which is to be done. The order that you are talking about is the EP order.
Your lordship may just add one line more. That let the order be released in terms of your lordship's order. Then I will go and seek a clarification. Your lordship may say, let the deposited amount be released to me in terms of the 17th September order.
Say in terms of the executive court's order.
No, I'll never get it. It'll become
You'll rather close it.
No, then your lordship may
some
say.
Amount of security, Mr. 34 is pending.
Correct. 34 decided. I have 134.
Pending.
Only 37 pending. In 37 cases, your lordship says, deposit the entire amount. 50.
We have recorded 1 minute. We have recorded the known affidavit, right?
Yes.
In view of the above, the amount shall be released. In view of the above statement, the amount shall be released. That's it.
By the trial court.
The amount shall be released.
By the executing court.
Within a period of 6 weeks from today.
All right. Grateful.
So, unless it's secured, from where it will be
my
recovered.
Friend has never even
order is very clear.
My friend has never asked for security.
Amounts to modification of executing court in this contempt proceeding, with great respect,
Your executing court has modified our order.
Yes, yes.
Please remember that.
Grateful. Great.
Next.
As you
My lordship, they are wasting vacating handing over possession.
Yes.
We have complied the order and they are wasting the precious time of this honorable court. They have filed the contempt petition. Thereafter, we have given the possession also. Execution has closed the, passed the final judgment of the execution.
Interim deposit to be released and 50% to be released and 50%. Oh, sorry, which item is this?
43.
Oh, that's a contempt for non-compliance.
Vacant possession.
Vacant possession.
As I appear for the landlord, in November 23, your lordships had given time to the tenant to vacate till 31st March 25.
Yes.
The possession has been recovered through execution on 22nd July 25. Lords, after a period of 4 months. Your lordships
July you got possession, is it?
22nd July 25. Now, my lords, thereafter, my lords, the
You got possession 22nd July.
yes, 22nd July. I have received possession through execution. Thereafter, my lord,
question of delay.
That is the delay. My lords, also, your lordships had directed it to be as per the usual undertaking. My lords, the undertaking as was continuing before the High Court was that the tenant was paying a sum of 1,25,000.
My lordship, we have filed the, my lordship, the scenario was, we were about to vacate and hand over the possession on 31st March. Thereafter, before, in December 2024, they filed a execution petition before the Saket rent controller for the execution of the orders. Thereafter, we received a summons from that particular court 5 days before, and thereafter,
March 24 more than a year. More than a year. You delayed it.
No, my lordship.
No, to hand over on 31st March 24.
31st March 2025. My lordship may see that application. We have given that particular keys in that particular court. Affidavit is attached. We have handed over the keys to the court on 26th April. Yes, my lordship. Yes.
But that's not a compliance. You should have handed over. When was this filed?
This application, my lordship, on 26th April. Before that, and
26th April when?
2025. We were about to vacate the premises on 31st March 2025.
You were to vacate by when?
2025, my lordship. 31st
March 25.
He was the order says 24.
24, not
31st
25.
March 24.
No, my lordship, 2025.
Second November order.
That's what we are now to understand. Is that a mistake?
No, the order says 25. I'm sorry, the order is at page 17 of the contempt petition.
The one we have is about 50.
Page 15, it is showing 24. Page 17, it is showing.
Page 15 mein kya hai?
Just see page 15 also.
Yes, because page 15 is not the order passed in this case. On that day, the lordships had passed several orders. Page 17 is the
April you filed this up.
Yes, it was a 20 days delay because of the execution petition they filed in the sun.
My friend, I'm just a minute. The lordship may just give me 1 minute. Lords, my friend is making an incorrect statement and I can prove it. The order of the executing court itself says
25, no 2 months delay.
because there's 4 months delay, but there's also a question of cost. He's left electricity of 1,62,000. He's left
that should recover from it.
because that he's left mean profits of 5 lakh rupees.
That can recover. Okay, we are not inclined to interfere with application in the contempt petition. In your statement that possession has been handed over to the petitioner, to the petitioner
landlord. I am the petitioner in the contempt.
Petitioner landlord. We make it clear that the petitioner landlord will be entitled to recover any amounts due from the respondent by filing by way of initiating civil proceedings, if necessary, if advised and necessary.
But my lordship may mention that we have already paid the amount. We have already.
That part is disputed. Because at least the rentals to the date they vacated.
All that you will
obliged.
Highly obliged.
This is that case. I passed 12th, they say you failed 10th. So, but it's your lordship in the peculiar facts of the and circumstances of the case.
I'm appearing for CBSE. Your lordship, the student has admittedly not completed. She's not eligible for appearing in class 12 examination. It is a fact. She passed her compartment
Is
exam.
now finished her 12th also?
Finished her 12th.
Your lordships, for appearing in class 12, you need 2 years of complete education. She completed her compartment examination. She qualified in 2020.
The facts and.
Your Lordship,
Say,
mainly see, I have
exceptional case
all
to
on record. It for actually a connivance of the petitioner and the student. And
No. I am for the school, my lord.
Your Lordship, we have actually issued a show cause notice to the school. That is also.
Yeah, you proceed against the school.
And Your Lordship, the school has accepted this. That
My lord, kindly just see what
She passed the 10th in 2019.
No, Your Lordship, that is wrong statement. She passed it in 2020.
10th.
Yes, Lordship.
I'll just raise the fact.
19, she failed in her exam, and then even the first.
She was admitted in the 11th standard.
she was a direct admission, my lord.
And first attempt she made in July 2019.
That
The 10th examination.
that was unsuccessful.
And then she
She appeared
cleared
again.
the exams in 9th standard, and then again made the second attempt for the 10th in April 2020.
2020, and then
She's admitted in the 12th, but she gave the final examination of 12th.
in 21. How can that be possible?
Lord, it is as if
She passed it in 2020, and it was a wrong admission on
The second attempt she passed, no?
she attempt. Yes, Your Lordship. So how can then in 2022, how can she appear in 12th examination? Your Lordship, the CBSE bylaws are very clear.
my lord, it is as if the CBSE has no responsibility. They are putting it upon me. Kindly just see. No, the CBSE has done it. I have already responded to this.
Today, it doesn't matter, Sheshadu, but ultimately, only an order, which is the order that he has challenged is the order of withholding appearing in the 12th class, is it?
Yes, Your Lordship, but then she was not eligible to appear in 12th. How can CBSE issue a certificate in that case?
But she's now cleared.
That is subject. Result is not out, Your Lordship, because CBSE has withheld it because she is not eligible as per the CBSE.
What does the rule say?
In 40,
Candidate 42.
42.5, Your Lordships, in my counter, I have annexed the bylaws.
The candidate placed in compartmental may appear at compartmental examination to be held in
42.5,
July,
Your
August,
Lordships, may see.
and may avail himself herself the second chance in March.
Your Lordship, may kindly see 42.5. The
42.5.
candidate who is placed in compartment in the secondary school examination class 10 shall be admitted provisionally to class 11 till he passes the first chance compartmental examination to be held in July, August of that year. His or her admission shall be cancelled if she fails to pass at the first chance of compartment examination. So admittedly, she has not passed, and that is why her provisional admission is cancelled. And Your Lordship, the registration form,
May I say something?
she has written wrong.
Well, it's-
2019.
Your lordships have the appendix, page 27. Well, it's page 27, rule 42.1. Your lordships may read it. Well, I'll be fair. I'm an officer of this lordship's court. So I'll be fair. 42.1, Millets. May I read, Millets? May I read?
Yes, yes.
A candidate placed in compartment may reappear at the compartmental examination.
So what's the present position of your
The
client?
present position, Millets, is I at some level, Millets, I see why the rule makes sense. The rule states that if you have a compartment, you get 3 shots at the cherry. One is in August of the same year. The second shot is in February.
What's the position?
She is now,
She's taken the 12th exams are over.
she had appeared in the 12th exam because they didn't release her certificate. She had to go through open
She
school.
appeared.
No.
No. So this was the pandemic year. Your lordship's judgment in Mamta Sharma gave a tabulation of 10th, 11th, which meant that the result of 12th was derived. According to that, she's passed. If you see the Mamta Sharma tabulation, which is a mixture of the 10th result and the 11th result, she would have passed.
You are arguing the case. We are asking you what's the present position so far as she is concerned.
She's cleared 12th.
This 12th is cleared.
Yeah. From open school.
Not because, not from CPSE, from open
No,
school.
of course. That's what. You've not released the results, so it's assumed that it's not from CPS.
CPSE has no role now.
Well, in that case,
There will be 2 boards. If she has cleared her 12 from open, now CPSE can.
no. But I had filed the writ petition.
It's not making it as a precedence. We will direct you to declare her result.
Your Lordship, she has already cleared her 12th from open. Now CPSE cannot. She will have then two results. How can that?
Did you clear?
No, in 2020, I don't know. I'll have to see.
Then?
20, maybe 2 years later.
No, but then you've taken it from open exams.
Open exams. Open system. No. What will happen? Immediately when my results were not declared, I go to the writ court. Writ court does not give me the relief and I'm eventually here. Immediately after, when it's not released, I go to the writ court. It's not as if I've delayed.
You will have two certificates.
No. Well, that would have, I'll withdraw that. I'll give an undertaking that I could.
Withdraw it.
No, the situation is here.
She passed the open school, is it? She took the
Open exams, yes. Open exams does not have as much acceptability as much as the CBSE certificate.
Your 12th results.
They have withheld my 12th result.
Because she was.
Because what would I do? I had gone to the writ court.
What is she doing now?
She is right now in BSc nursing. Yeah.
That she's taken admission on the basis of her open.
If my esteemed senior colleague may not be pedantic about it, it's a 21-year-old girl, my lord.
So, Your Lordship, this is the bias.
It's not going to be a precedent anyway. If your lordships specify in the circumstances.
We will have to completely eschew the open passing of the 12th from the open examination. But only thing is that 12th she has anyway passed. So the difficulty is only arising because even after the second attempt, do the exact date when.
She appears for the 10th examination in March of 2019.
Correct.
She gives the compartment examination in mathematics in July 2019.
March 2019.
March 2019, she appears for the 10th examination.
Failed.
Gets only one subject.
Failed.
Okay, correct. Compartment exam she gives in July, August of 2019. Is not able to clear.
Again, she didn't clear.
Rule gives us 3 attempts.
Next.
Then February, March 2020, she gives the second compartment. Clears that.
Second compartment.
In the same year, in the same month, she clears 11th because she was given provisional admission into 11th. So in 2020, she comes into 12th. In 21, she appears for the 12th examination, not the examination, but Mamta Sharma gives a tabulation. So
2020, she clears the
11th also.
No, 11th is cleared earlier. 2020, 11th she has, in the meanwhile, 11th she has come, she has cleared 11th in 2020.
So,
and so far as the 12th class, the 12th examination is concerned?
12th in 2021, her result was not released, but she would have cleared it because it's as per a tabulation that this honorable court has only set in Mamta Sharma,
Your Lordship,
which is a combination of 10th and 11th marks.
Just 10 and 11 in 1 year, how can she clear? That is the problem.
If your lordships
faces.
If your lordship see the tabulation also, it says 3. So let me assume.
So what will be the way out for her?
Your Lordships, it is that way. If
What's the way out for her?
If she's cleared it through open, then she is very well eligible.
So no concern to you.
But CBSE cannot declare the result in gross violation of these bylaws.
So what happens if somebody is not able to clear in 2 attempts, he's gone forever?
They can appear next year. This is a provisional admission that they get.
So you say that they will get the 12th after passing the.
And they will pass. Yes.
She will lose over 2 years.
She will lose 1 year. Because if she passes in 2020, then she will need 2 years.
No. So the peculiar fact here is, my lords, if the rule is to be understood the way they are understanding it, she'll have to repeat 10th after clearing 11th and 12th.
The provisional admission should have been cancelled.
It should have been cancelled because I'm not.
I should have cancelled the provisional admission.
I've conceded on constitutional validity of the
1 year delay. What will happen?
Miloj,
you can't have the force to bail you.
Miloj, I get that.
Three times you.
Miloj, I get that. Miloj, Miloj, at the end, there is a regulatory responsibility for them to convey.
Don't put everything on their shoulders.
Yes, Miloj.
Don't stretch it so.
One exam, one mathematics exam. It's not as if she's failed other exams. Miloj, 4 subjects she's cleared. Only for maths compartment, if the understanding is that she has to repeat 10th, look, that would lead to an absurdity. With great respect, Miloj.
That is not for one
for
student.
only maths. I've only failed in maths. Miloj, on a lighter note, even I had failed maths in 10th.
Excuse.
Miloj, your lordship, the peculiar facts and circumstances may help me, Miloj.
We have to.
Miloj, only and then I clear it. It's not as if I've not cleared it.
Try and see some.
No, Your Lordship, I've taken instruction. This is not one student, Your Lordship. This is CBSE bylaws.
Give us a short note.
Yes, ma'am.
We'll put it up on Wednesday.
Miloj, exact same facts. Let me see.
6 facts, yeah?
Exact same facts. Punjab and Haryana High Court, same rule. Took a opinion in the favor of the student. The impugned judgment also cites it. Your Lordships may see para 22 at page 12. I've read that judgment, exact same, 42.1 and 42.6.
Wednesday.
Exact same case.
Come on, Wednesday, we'll have a look, we'll try and bail you out.
Miloj, I'll be grateful, Miloj.
Your Lordship, I have my counter as well as the bylaws on record. Your Lordship, CBSE bylaws don't permit.
It will in such a way that
Miloj,
we will not entrench upon the law.
school promoted me, Miloj. That's why I would not have known.
That is my case, Lordship.
That's you next Wednesday.
Confinements with the petitioner.
If you had told me on that day,
Come on now, Wednesday.
grateful. I'm very grateful for a patient here.
45.
Please, my lords. My lord said.
The remaining matters will take it up on Monday.
Very well.
Lords, may I mention item 4 with your indulgence? This is the bail matter where Ms. Rohatgi appeared on the other side and the learned ASG was here. The learned ASG has been informed. Lords would note that there was an additional affidavit in the matter which said that Lords, the indulgence I want is that a statement was made at bar that the investigation is complete. Now, my lords have dismissed my bail and given me liberty to renew it in 3 months. I'm praying for the indulgence that that what the learned ASG submitted on instructions may be recorded in the order. Lords, when I
No, next. We'll just take the matters on.
My lord,
All these matters will come on Monday.
52 is a fresh matter. Your Lordship may take it, but if it can tell, it's
Monday.
my lord, 50 only has to be tagged and interim order. Everybody is
Okay.
50. I'll just
Notice and post along with that.
And my lord, interim relief is there for everyone.
Josefa, your matter will take time. I don't know why repeatedly it comes on it. Monday, I don't know. It should be posted on a non-miscellaneous day. Which item was that?
That was my lord's item 48.
48 only. My lord, item 50, there is also an interim order for everyone. So
Same order. Item 50, same order.
Your Lord, 46, there is an interim relief that may kindly be continued. Item 46.
All interim reliefs will continue.
Item 47 actually is an appeal. I do not know it has come up today. It has to be heard.
Lord, there is some urgency in this, my lord. The consideration of CI has been all, my lord, hundreds of.
On Monday, you can tell us.
Lord, will Lordship have it on any Tuesday or something? No, because matter will have to be heard, my lord.
Hearing them, my lord.
Otherwise,
it has to be
urgency. All projects are stalled.
Stalled, my lord.
Let it come on Monday. We will take a call.
Oh, very well.
We will take a call on Monday. All matters will come. All matters will come on Monday.
But item 40.
Yeah, just about 6-7 matters left. That's all.
6-7.
But your lordship, we have the board.
48 will come on non-miscellaneous day, your lordship. Just
That your lordship have already said. The same matter.